now the first speaker will be Petro Sukhorolsky. I'm happy to welcome here, and he will be also the moderator of our first part of panel discussion. So I'm happy to welcome Petro Sukhorolsky here. Petro, over to you. Thank you, Natalia. Thank you for this great introduction. And I'm happy to see all of you here. And I would like to mention that all our events, their performance, effectiveness and efficiency actually it doesn't cause any doubts. I have been dealing with the initiative law for quite a significant period of time, I think since 2010 or something like this. So I can follow those changes in dynamics both in Ukrainian legal field and in European field. And if 10 years ago those publications on information law or information human rights, they were quite diverse, quite different. There was no significant approach, and there was no unity in this community. And at least now, everyone understands each other, and we have this unity in our vision. And all previous speakers actually reflected it. Everyone speaks on topics which all are overlapping, and it's interesting to listen to our co-speakers. It means that the community, the environment of which actually impacts on such information processes as being built. And it means that we can contribute to building such communities, such an environment, and it could help to boost or to foster exercise of human rights in the information field. And also we can feel some kind of a progress in terms of such activities, meaning that we do not stay at the same spot. No, we are moving forward. So thank you so much for giving me a floor and for presenting my topic. Thank you so much, dear Petro. So I'm thinking back the mic of organizer, and I would like to tell you a few words about our project, which I have already described to you yesterday. Thanks to this project, we managed to arrange both this event and all previous events, which were quite successful. So specifically speaking about this ninth legal Kharkiv forum, there was a specific topic raised there, and this forum took place on 22nd, 23rd September. I don't know whether we have any participants who attended also that forum, but maybe you have also listened to it. And so for these 3 years, we have been implementing this project, which we were supported with by the Erasmus project. There were so many different events, and indeed, going back to what I have started with yesterday, I used some pathos, some extensive enthusiasm, saying that, telling you the story of this project, how we submitted our application, how we won it. And afterwards, I was reflecting and thinking, maybe it was too much to say, maybe it was too enthusiastic, but no. Now I think that everything was appropriate, relevant, and in context. And as I have mentioned yesterday, so this project was, application to this project was submitted in quite military mode. We didn't expect to achieve any success at all because the grant application was consisting of 100 pages and different project participants contributed to this process. Our actions were not that much synchronized because the full-scale invasion has already started. We were in Kharkiv altogether. It was quite hard to do. So it was so a big surprise to us when our project actually has passed to this stage of consideration, and we can say that it has I also didn't mention this information yesterday, and now we're providing you with this insider kind of information regarding the project of human rights in the digital era, Value Foundation's protection mechanism. So it was a surprise for us when we opened this grant application and we realized that the war has started and the different participants contributed to this grant application. Our actions were not synchronized at all, and each of us, did their best and even overtried. So it means that we declared in this project too many different activities, excessively too many activities. When the blackout started, when May 2024, the repeated offensive attempt on Kharkiv started. So there were challenges, how to have such activities, how to have such events, how to carry out studies, how to publish articles and so on. But anyway, we managed to succeed. That's why I would like to dedicate right now a little bit of our time to resources and information and the content of those publications which we did within this project, and also events which we arranged within this project. Just again, to reiterate, there were so many events and publications. Again, why? Because we just overstated and over-included all those activities and events in our grant application. But anyway, we don't regret, and as of now, all is good. And yesterday, I shared with you the website where we have all our outcomes published, outcomes received for these 3 years. And again, I would like to pay attention to European fundamental values in the digital era. That's the joint monography. It's that's in public access, and I will share with you a link to this monography in the chat. So what's interesting about this monography? Here we have the concept of European fundamental values in the digital era, rights, principles, and data protection. The first theme. Second theme, implementation of European fundamental values in contract and tort law. And the theme number 3, procedural aspects of the implementation of European fundamental values in the digital era. So it means that in this monography, presents the concentrated place to accumulate all outcomes and all novelties and developments of the project. So the monography is fully free of charge and in public access. So the first link for those who are interested in. So please download and enjoy it. So, and what else is important regarding our outcomes with an implementation of the project? These are numerous activities which we have carried out within the framework of this project. So, with it to say, we carried out 12 workshops for students, and I would say that these were such like presentations together with discussions. And we, with involvement of our students, and I would like to say a big thank you to our students, to express my sincere fascination of their involvement, of their attitude to those workshops. And so they were so curious, so involved, but at the same time, Their presentations were full of evidence and science data. So again, it confirms that despite of any challenging circumstances, our students contributed so much to such events. And I remember it was in March of 2022, and I received a message from one of our students who said there that, dear Natalia, I prepared presentation on the topic of responsibility for decisions and actions of AI. So why you do not have any events on it? And I asked her, where are you right now? And she said to me, I'm in Kharkiv. So I'm so grateful to our students. And as of now, there were 6 workshops for practitioners. Among those 6 workshops, there were even workshops dedicated to digital assets such as cryptocurrency, virtual assets. And to my opinion, this workshop was very interesting. Also, there was another workshop dedicated to intellectual property issues where very famous and practitioners and scholars having authority in this topic had a floor and presented their speeches. The same forum which I mentioned before, which took place on 22nd and 23rd September, forum dedicated to right to be forgotten. This forum also attracted a lot of attention. And now, without any other words, I just would like to show to you YouTube page with recordings of all the videos of all the events. So here we have workshops for students, workshops for practitioners, and panel discussions. So all events which took place during those 3 years of implementation of the project. So that's the YouTube channel of the Center for Law, Ethics and Digital Technologies, which functions under auspices of Yaroslav Mudry National University. It hosts and welcomes our projects. That's why we use their YouTube channel in order to publish all our developments and all results of our project. For example, here we have a workshop for students. And here we have a list of workshops. Here the topics are so interesting. AI and intellectual property, legal responsibility for using AI. So agreement click and wrap and browse wrap and process of mutual recognition of e-signatures, online courts. So many different topics which actually are so acute right now. They're so on the table, but at the same time, the topics are not narrowed, they're diverse. And here again, other workshops practitioners, here we have the issue of access to justice and intellectual property, digital assets, and there were also several workshops dedicated to online platforms. And here we also have panel discussions and conferences, and we have schools for young scholars. That's our so-called methodological schools, where we share with the audience different life hacks, how to publish your academic developments and articles, exchange our experience. There was also a workshop dedicated to the networking, how to build networking in the academic field, how to start communicating with different colleagues from different countries in order to establish friendly relations in such academic fields. That's why I kindly invite everyone to review videos on this YouTube channel. I do not urge you to do any other actions in order to promote this content on the YouTube. It's not our goal. It's not our methods. Our key goal is outreach, is educational. You know, indeed, for us, it's important. It's valuable, and it's so close to our hearts. If such videos are watched and they have their own audience. And the most important for us, if such videos bring some benefits to you, some gain to you, that if you find something interesting there, for our efforts not to be in vain. So we are happy to share those links to those videos with you. Please watch them if you have any interest. So Petro, over to you again. I know that you wanted to mention something else regarding our project. Thank you, dear Natalia. Yes, I would like to mention that during implementation of all activities, we actually came closer to understanding of the problem at hand. Actually, in Ukraine and in particular in the European Union, so many different laws and acts have been adopted because the number of laws has increased significantly. And yeah, indeed, so laws are being developed and adopted, but the general situation does not develop towards solution actually of the problem, solution of the challenge. And yesterday's speaker actually mentioned the backsliding, the regress which we can observe for the last years. Why is it so? Maybe we don't understand the reasons, but now we already understand the problem itself. So now we need to focus more on the solutions, on what is our legal base missing, what are key fundamental gaps and drawbacks which do not allow us to solve those problems. So I think that I will mention those things in my presentation. I think we will speak today a lot about artificial intelligence, about accompanying technologies, and how to solve any such challenges related to it in the legal field. So shall we move to the presentation itself?
So I totally agree with you, and we mostly go to the essence of our today's panel discussion and coming back to some technical organizational issues for those who have just joined. I would like to say that we have changes today in our schedule of our panel discussion. The matter is that because of personal reasons, speaker Alexei Kostenko, so the second speaker for today, won't be able to join, and Mr. Andriy Hechkevich, who was to speak first, will be speaking at 11 a.m. And now, taking into account these changes, I present my colleagues. I presented him already, but now I will speak in more detail. So I present our first speaker and the moderator of the first part of the panel discussion, Mr. Petro Sukharolsky. Mr. Petro Sukharolsky is PhD in law, associate professor of the Institute of Humanities and Social Sciences of Lviv Polytechnic National University. He is an author of the book Foundations of Future Studies 2021, as numerous publications devoted to human rights in digital era, data protection, challenges of the informational society, and other topics. Mr. Petro is a full member of the World Future Studies Federation, and his research focuses on the influence on informational technologies on human rights and international law. And also, I would like to add that Mr. Petro is a brilliant speaker at all our events, which were organized in the framework of the project, and it's always very interesting to listen to his speeches, and you can always find something new, some new aspects which surprise you in every topic on which he speaks. So I gladly give the floor to Mr. Sukharolsky, please. Thank you, Ms. Natalia. It's a pleasure to have such a great introduction, and I hope that today the speech will be interesting too. I'm now sharing my presentation. So my speech is devoted to the value of personal autonomy. In the previous days, Yulia Razmetaeva, leader of our project, has raised this issue of whether we need to add or reform something in the list of human rights, which was formed 2 centuries ago. This human rights and values enshrined in them, are they enough for today? And there are two approaches to that. The first one says that we do need to review this catalog of human rights and create new points where we will create balance in the future. The other approach says that we can continue using the existing catalog of human rights, adding something from time to time and interpreting its provisions in new ways. The second position is predominant now. Why? Because there are no efficient abilities to reform something fundamentally. But a lot of factors show that the reform is needed, it's urgent, and the circumstances in which the French Declaration of Human Rights or the amendments to US constitutions, the circumstances were different and the centers of power were different. The society was different from now. So today I will be speaking about what we lack in law, in legal acts, what gaps exist which don't allow us to see the main problems and don't allow us to fix the problems. So my speech deals with personal autonomy as legal value and how it is influenced by modern technological challenges. So when I speak about this topic, I always show to my students this slide and I offer them to think about the issues, what wishes and interests every person has. That's the first question. And the second question is who can best answer the first question? Who knows best what interest, wishes, and needs every person has? So there are several options. The first option is those who create ideology. In the past, these people used to say that they know best what people need, that people are not ready to understand their real interests and needs. If we speak about children, the same position also prevails among their parents and relatives, so we limit their independence because we think that they don't know what their real interests are. We can also turn to psychiatrists, psychologists for consultations, and they will tell us about our real needs and interests. At the same time, the market, economists, and other specialists study our needs and interests and their success and their profits depend on that. They employ smart algorithms in this process, but these algorithms have new dynamics with the advent of artificial intelligence. They can scan a person and find a person's strong and weak sides, and the final option of the answer is the person, human being, he is or herself. So if it's true, does any person know the answer, or are there any criteria? Because we understand that our people with some limitations. If the legal system devoids them of their abilities, so this person without full legal capacity cannot understand their needs and interests. So we see the conflicts in the sphere of needs and interests of every person, and we see this example on the bottom of the slide. For instance, almost every smoker have conflicting wishes to smoke and to quit smoking. How can we treat these two conflicting wishes? Which one is real? Do we need to nudge the smoker to quitting smoking by some manipulation of some enforcement? Well, there may be different answers to this question, so we lack some element which would allow us to answer this question. That's why I move to the topic of personal or individual autonomy, which is discussed more and more during recent years, and I will try to answer the questions which you see on top of the slide. What values should we defend? Why personal autonomy is important? What are the threats of AI and other modern technologies for such autonomy? And in the end, we will analyze modern legal acts and see whether this value of autonomy is enshrined in these acts. Is it protected? So traditionally, when we speak about informational rights, or for instance, the right for personal data protection, we speak about three values: privacy, freedom, and dignity. And the dominant view is that these three, values are sufficient, and on their basis we can build a system of rights and interests protection. I'll try to prove that this is not enough, and we also take into account the value of personal autonomy. And this autonomy is not copying the previous values of privacy and freedom or dignity. It's absolutely separate, and it deserves own representation in legal acts, and to be fixed. Rights based on it must be also described and fixed. To understand better difference from freedom, for example, let's take a look at two most well-known dystopia which are read by everybody. If we look at Orwell's dystopia 1984, we have a totalitarian society. There is no freedom, at least amongst the party members. Trolls have some freedom, but it is said that freedom is allowed for them because they have no intellect. Let's remember this phrase, we will come back to it. If we look at the work of Huxley, we see broad freedom for inhabitants of this world and for visitors like this John the Barbarian. He has complete freedom. He can go where he wants. He can speak. He can convince other people. So he has freedom, but it doesn't help because all other people act as a mechanism, as elements of some machine. They don't have autonomy, but they are completely satisfied, and they believe that they have freedom, although they do not have autonomy. John has autonomy, and he tries to keep it. In the end of the work, he is isolated at the distant location, but the system doesn't allow him to live alone and support his autonomy. He is used for films, for entertainment, so he ends his life with suicide because the system doesn't allow him to be autonomous. Because if it is built in such a way, according to principles which do not allow autonomy, every certain person also cannot be autonomous. So in this example, we see difference between autonomy and freedom. So we can also see the difference between autonomy and privacy. We can say that the John from the book wants privacy because he isolates from the society, but if we look at his previous past, we see that he didn't try to keep his privacy. He tried to influence the system. He went to people and tried to convince them. So the privacy was not his value. He wanted to change the system, which he didn't like. He tried to influence the system. So we can say that the privacy was his primary goal. We see it here that the autonomy is under threat in this system. Let's take a look at another example, which is more modern. Well, Neil Mohan, top manager of YouTube, says over 70% of time which you spend on YouTube, you are viewing the reels prepared by us for you using AI algorithms. And he says that to prove that their algorithms are perfect, if they can prepare offers for us, which make us spend 70% of our time there. And also, if we look at the dynamics of this time, people are spending more and more time on the platform, so it proves the efficiency of the algorithms. But the opponents will say that it doesn't prove the efficiency of the algorithm, but it proves the company's manipulations. So we have a question which every social network users face. Do we really want to watch these? Do we really need it? The things which we have in our endless well, social networks. In many EU countries, social networks are banned for children. There is a discussion about the ban of TikTok before a certain age. So why? It is said that children cannot fully realize, understand their needs and control them. They are unable to be fully autonomous, and the social networks, well, employ this fact and influence children and prepare devoted fans of their services. So this example clearly shows us that autonomy is really important. And now we go to the detailed analysis of its nature. The individual autonomy is a central, basis for liberal philosophy, which is seen in John Stuart Mill works and other works of liberalism's theorists. But at the time when they prepared their works, they didn't use the word autonomy itself. But if we read their works, we can see hundreds of references to what we today call personal autonomy. The modern theorist of personal autonomy clearly formulate the statement that autonomy is the most fundamental value, which is basis for everything else. They say that it's also basis for freedom and dignity. Like freedom and dignity is only possible when there is autonomy. And really, if we don't have autonomy, the person is not subject. And thus, a person cannot have nor freedom nor dignity. They are just elements of machine, such people. So they say that a person is master of their life and must make choices and be responsible for that. And another quote, autonomy includes multiple goals and interests at the same time, even conflicting ones, and the person can make different choices, including changes of preferences. So these phrases allow us to solve the smoker problem. Should we nudge him to quit smoking? No, we shouldn't, because a person has multiple goals, conflicting goals, and that's natural. And we have to create such conditions that a person will be ready for certain decision in time. And if some people will choose to smoke, that's not a big problem for the system. It's just a answer to the demand for variety in the system. And if we will use an enforcement to and coercion to make people quit smoking, well, it won't be the best decision, because autonomy is a most fundamental value, and limiting it requires much greater justification that health issues in case of smoking. So the words of John Stuart Mill show us that autonomy is a central element of his philosophy. He says that freedom deserves its name only if we reach our goals ourselves. So not only the results is important, but the way to these results are also important. For instance, if a child is forced to follow certain paths, gets to some success there, but not because of his or her choice on that path during his or her life, but only due to, well, coercion, such situation cannot be treated as positive situation. There always should be a freedom and the path of a person, responsibility of a person. Only then we can have maturity. Otherwise, uh, we have the image of well, childishness, immaturity.
And for example, if you look at a picture where there is a small child near the fire with some kind of a bucket with a hole. So they show to us what humanity looks like, that we are small children, that we gave an impetus to develop new technologies, but we don't know what will be next, and we do not think about what will be next. It's very well correlated with the theory of autonomy. When autonomy is delegated, only then a person could raise to some kind of mature age, when this person makes decisions, assumes responsibility for those decisions, and envisages some outcomes of those decisions. So freedom, and as John Stuart Mill has said, freedom is worth of being called freedom only when outcomes and achieving of benefits for us is done using our own methods. So it means that we shall tolerate the actions of other people, even if we don't like
для
it,
того,
but only
щоб
till
ми
the
могли
moment when
судити про виправданість певних
such
втручань
actions
у права
start
людини.
harming
От в
or
кінці є
posing
якраз
risk to
деталізовано
autonomy
це
of
положення.
other people.
Держава може
So
застосовувати
autonomy is a
примусові
key thing, and
маніпуляції, тобто
it means that
зменшувати
the state
персональну
even can use some
автономність
manipulative
однієї людини
measures,
лише коли
meaning
це
to decrease
обґрунтовано
the
захистом
individual
персональної
autonomy
автономності
only
інших осіб, тому що
when
це фундаментальна
it's
цінність,
motivated
і
by
відповідно
protection of
іншими
personal
критеріями ми не
autonomy of
можемо
other people, because autonomy
виправдати
is a fundamental value, and we
втручання у
cannot
персональну
justify
автономність. Тому що знову ж
intervention
таки,
in
якщо ми
personal autonomy
знищуємо
by any
персональну
other
автономність, ми
reasons. Because
перетворюємо
again,
людину в
if we
об'єкт, ми позбавляємо
destroy
її
personal
суб'єктності
autonomy,
і
individual autonomy,
позбавляємо її людського,
we
тобто робимо її
shift a person from a subject
дегуманізацією,
to an object,
дегуманізацією
and
і
also this
десуб'єктивацією,
person
і
goes
таким чином
through
це
desubjectivation
недопустимо,
and
але може
dehumanization
бути
process.
виправдано
It
тільки
means that it's
заради захисту
unacceptable. It could be
персональної
justified
автономності інших
only
осіб. І
for the
знову ж
sake
таки
of
тут повинен
protection
бути
of individual
дотриманий принцип
autonomy of other persons.
пропорційності,
At the
тобто
same time,
якщо втручання в
proportionality
персональну
principle shall
автономність
be
однієї
maintained
людини дуже
here. It
велике,
means
то це
that
має бути
if
обґрунтовано
we have
величезною потребою захисту
individual
персональної автономності
autonomy
інших осіб.
of one person is
Тепер
limited to great
подивимося на
extent, it shall
умови
be
автономності.
justified
Умови автономності це
with
головний
need
категорій,
to protect individual
через
autonomy
які
of so many
розкривається
other
сутність
persons. So
персональної
let's
автономності,
look at
і
different
через ці
conditions
умови
of
ми можемо
autonomy.
краще
So
зрозуміти
those
загрози
conditions help
для
us
цієї
to better
цінності.
understand
Загалом
threats and
автономність
risks
не
to
є
this
природним
autonomy.
правом,
Generally
це є
speaking,
право,
autonomy
яке
is
є
not a
здобутком
natural right. No, that's the
цивілізації.
right
Тобто у
gained by
природному
people through
стані
the civilization
автономність
process. So
зведена
it
до
means that
мінімуму.
in
Там є
natural
біологічна
state,
автономність,
the
оскільки кожна
autonomy is
особа вона є
minimal.
окремим
Because
біологічним
yeah, we have
організмом,
biological
автономним
autonomy
біологічним
because
організмом.
each
Але
person,
в
each
плані
human being
особистості
is
автономності
a
немає.
separate
Чим більше
individual
зростає
autonomic
цивілізація, тим
organism. But
більше
generally
зростає
speaking, we
і
don't have
автономність. І
autonomy
відповідно,
in
чим
nature.
більше
And
зростає
the higher
цивілізація,
is the
тим
level of
більше
civilization, the
зростають
more
умови
developed the
автономності.
civilization, the
Умови
more
автономності
autonomy is developed.
вважаються
And it means the
колективними благами,
autonomy
і
conditions
завдання
are also
уряду
more
їх
developed.
розвивати.
So
Тобто хороший шлях,
conditions of
шлях прогресу,
autonomy
це коли
envisage collective
уряд
benefits and
чи
the
інша
task of a
влада
government
дбає
or
про
of any
розвиток
other
умов
power to develop
автономності.
them. So it means that a good
Дивимося на ці
government shall
умови
take
конкретні.
care
Перша умова –
after development
наявність
of
ментальної
autonomy conditions.
здатності
So let's
людей,
look
які
at
дозволяють їм
key
бути автономними.
conditions of
Тобто,
autonomy.
в
The
першу
first
чергу,
one
це
is
йдеться про освіту і виховання.
presence
Це
of
йдеться
mental
про
capacity of
освіту,
people
зокрема, у
um,
галузі
which
соціально-гуманітарних
allows them
дисциплін.
to be
От коли
autonomic.
були часи в історії людства, що людство
Going
йшло
back
вверх, а
to
не
the
вниз, коли
past
відбувався
when
прогрес,
the
наприклад,
progress took
так,
place
тоді
rather
в ті
than
часи
regress.
якраз
At
і
those
була велика
moments,
увага
there
до
huge
того, що ми
attention was
сьогодні
paid
називаємо
to what we are calling right
соціально-гуманітарною
now
наукою.
social
От
and
ви звикли говорити,
humanitarian
що
science.
десь у середні
So
віки
we are
була дуже
used to
погана ситуація
to
за різними
say that
критеріями. Але ж
um,
після середніх
in
віків
medieval
настало
age,
відродження і новий
there was
час.
so
Значить,
bad
оцей гетьманський пізнє середньовіччя,
situation
воно
with such
підготувало
criteria with human
ґрунт
rights. But
для того,
then
що люди виросли,
Renaissance
і
came. It means
підготувало
that
ґрунт для
medieval
того, щоб
age
до влади
prepared such a
прийшли еліти,
platform, such a
такі,
foundation
наприклад, як
for
під
further
час революції
developments.
у
And
Франції
for
і під
example,
час
during revolution in
війни за
France
незалежність у США.
or
Це були еліти, які були
independence war in
найкращі
the
філософи
USA,
свого часу, і вони могли вільно
we can
формулювати інноваційні
see that
ліберальні ідеї,
um,
писали філософські трактати,
that
які ми читаємо
elites
дотепер.
in different
Тобто, відповідно,
countries,
були
such
створені
as these
умови,
countries,
коли
so they
найкращі
took
люди,
to they
представники свого часу, могли
came to
висунутися
power
наперед
and
і
they
творити
further
історію.
started creating
Значить, відповідно, були
history.
часи,
So
коли
it means that there
оці,
were also
скажімо, гуманітарні
other times when
науки і
such
виховання,
social and
вони сприяли
humanitarian
тому, що суспільство
sciences
рухалося
and
вверх.
bringing up
Це я
of
говорю до оцієї першої
children
умови,
actually
наявність
helped
ментальної здатності людей, які
the
дозволяють їм
humanity to
бути
move
автономними.
forwards, to
Тобто,
move
знову ж таки, ми
upwards,
говоримо про те, що
so
не
to
можна
uh,
взяти просто
mm,
біологічну людську
commit
особину і сказати, що вона
progress.
є
So
автономною.
we can't
Саме тому ми
take any
забираємо
human being and say that
дієздатність
this
у
person is
неповнолітніх. Так, ми
autonomic.
обмежуємо
That's
її,
why
тому що ми
we
говоримо, що
take
людина не автономна і не може
agency
бути автономною, наприклад, у
from
малолітньому
minors.
віці.
because we say
бажання
that
батьків і
a
системи
minor
виховати
person
цю автономність, щоб
cannot
людина
be
самостійно могла приймати рішення,
capable,
не займатися,
cannot
ну скажімо,
have
надмірним
autonomy. That's why we
плеканням
delegate their
цієї
powers to
дитини
their
і
caregivers
враховувати
or
її
parents.
певні
We are
там
speaking
акценти,
about
так? А ми
their
говоримо про те, що
legal
нам потрібно її
ability right
виховати
now.
до
We
такого
say that we
стану, щоб
need
вона
to
стала самостійною
bring
на ноги
up
і
this
пішла в
child for
світ.
them to be
І
independent and go
відповідні
into
завдання
life.
ми ставимо і
And
перед
the
освітньою
same
системою. Друга
similar
умова
tasks
автономності.
are put in front of the
Автономності
education
адекватний
system. The
перелік
second condition of
доступних
autonomy
опцій.
that's
Тут
adequate
це вже
list of
напряму
available
залежить від
options.
держави
And
і
here it's
іншої влади
fully
у суспільстві. Очевидно, що
correlated with the
перелік доступних
state and
опцій
another
у
power
давньому
which
Єгипті
exists
він
in the
менший,
society. And
ніж,
of course, we
наприклад, у
clearly
ХХ
understand that, for
столітті.
example, the
Тобто
list of available
цивілізація
options
нам
which
створює
was
певні
available
засоби і
for the
певні
ancient Egypt
винаходи
is
нові, які
different, is much
розширюють
more
цей перелік.
limited than,
Але
for
не
example,
завжди
the same list
краще
in the 20th
означає
century.
більше. І
But
тому
not
Йосип Франц
always
говорить, що тут
the
ми
better
можемо
means the
застосувати
more.
тест
And here Joseph
різноманітності.
Franz says that
Оці
here we can
опції, які
apply
доступні для
the
нас,
diversity
вони мають бути
test. So those
різноманітними.
options
Чим більша
available to
їхня
us, they
різноманітність, а
should
не
be
кількість,
diverse.
тим
So
краща оця
it's not so
умова,
important to have a
краще
high number of
реалізована
them, of
оця
those
умова
options,
автономності.
but they
Тобто
should be
вибір
diverse.
між
The more diverse they are,
між айфоном
the
і
better
телефоном на
autonomy
андроїді
condition is
не
being
витримує
implemented.
тесту різноманітності, бо це
So,
фактично
for
одне і те
example,
саме. І
uh,
форм-фактор цих
Apple
телефонів
phone
майже
and Android
однаковий.
phone,
Тобто тут немає
if we
різноманітності. А
compare them
пригадаємо
and
собі,
if we
коли
apply to
з'явилася
them the
мобільні
diversity
телефони,
test, they would
різноманітність була
not pass
набагато
it. And
більшою. І це
because they're
чітко
actually
говорить
almost the
про
same,
випадок
even
саме
speaking
із
about form factor or anything
інформаційних
like this.
технологій. І
But
третя
it's
умова автономності
when
відносна
smartphones
незалежність,
were just
яка
appearing
виключає
on the
життя
market,
під
yes,
примусом
indeed,
чи
that was a
маніпуляціями.
diverse
І знову ж
test
таки в
successfully
цьому
passed. And the
плані
third
примус
condition
майже
for autonomy is that
маніпуляції
mm,
майже
um,
прирівнюються до примусу. В
conditional
той час, коли ми
independence,
говоримо про свободу і
which
дивимося на
includes
це з позиції
life
свободи, то
under
примус є набагато гіршим,
coercion
ніж
or
маніпуляції. Так?
manipulation. So,
Але якщо ми
speaking
дивимося на
in
це
freedom
через
terms,
призму автономності,
coercion is
то хоча процес
much
поставлення
harsher and it's
автономності є
worse than
різний,
manipulation. But from the
але
autonomy
результат
perspective,
є один і той самий. І
uh,
примусом, і
it doesn't matter
маніпуляціями ми
whether
можемо
it's coercion
досягнути
or
одного і
manipulation. The
того
outcome will
самого,
be the same.
тобто позбавити людину
So it means
її
that using
автономності.
any of it, we can
Персональна
take the
автономність, вона
autonomy from a
найбільш
person.
тісно пов'язана із позитивною
And the
свободою.
issue of autonomy
Ісайя
is
Берман розрізняє свободу на
mostly
негативну свободу
connected
від
to
втручань і
positive
позитивну
freedom.
свободу
And
робити
Isaiah
щось
Berlin
по-зовнішньому в світі і
differentiates
у
negative freedom,
суспільстві.
neutral
І
freedom, and
оця
positive
позитивна
freedom. This
свобода
positive
після
freedom to
його
do
робіт
something in
мала дуже
external
різні
worlds. And
інтерпретації, в тому
after
числі і
his works
нацисти
were
її
published,
використовували, так, і
positive
інші
freedom term
тоталітарні
was
режими
interpreted
використовували
in different
оцю
ways by
позитивну
different people
свободу для
and by different
пригноблення
regimes,
інших. Вони
including
говорили, ми
Soviet
краще
regime,
знаємо, що треба
authoritarian
робити.
regimes,
Нам треба
Nazis, and so on.
загнати
They
людей в
say we
концтабір і
know
написати,
what
що
people
робота звільняє.
need, and we
І
we need
ми
to
вам
put them
даємо
in the
справжню
labor
свободу і так
camp and
далі. Це
just
робили
say that
багато релігійних
um,
лідерів, чи точніше лідерів
labor makes you free,
тоталітарних
and so
сект.
on.
От вони
So
так
many
інтерпретували цю
religious
позитивну
leaders, many
свободу.
other people
І тому
interpreted
вона,
positive
скажімо
freedom in
так,
such a way,
відійшла на другий
and that's
план у
why this
наступні
positive freedom
десятиліття. Але
actually
якщо ми її оцінимо через
just
призму
was not
персональної
on the
автономності,
front
то всі проблеми
line of
із її
attention
інтерпретацією
decades
щезають.
afterwards. But if
Обща
we
складність
look
позитивної свободи
at
визначається
the
через
positive freedom
внесок,
from another
через її
perspective, then
внесок в
we can
автономність.
interpret it
Якщо
from different
позитивна
ways. So,
свобода сприяє загалом
volume and content of
автономності
positive
в
freedom
суспільстві,
shall be
тоді
defined through
ми
its
її захищаємо. Тобто,
so
якщо певні
contribution
якісь речі,
of
які ми називаємо
its element
позитивною
into
свободою,
autonomy.
вони
So if some
перешкоджають
things
автономності
which we
людей,
call
тоді
as
ми не
positive
можемо
freedom,
її
they become an
захищати.
obstacle
Тобто,
of
якщо нацисти
for
говорять,
people's
що позитив,
autonomy,
що
then we
ми
shall not protect it.
в
If
основу
Nazis say
своєї
that
ідеології кладемо
we
свободу
are
людини,
putting
то очевидно, що їхні
freedom of
інтерпретації,
people
вони
into
руйнують
the
автономність.
baseline
І,
of our
відповідно, це не є
ideology,
свобода.
then it's
Те,
clear
що
that
вони
they
називають
just
свободою, ми не
ruin,
можемо
they
назвати
destroy
свободою, і ми не
the
можемо цього
autonomy. What they
допустити.
call
Тому що, знову
freedom,
ж
we
таки,
shall not call
ми
freedom. We shall
робимо
not allow
висновок
it.
про
We shall not
позитивну
accept it.
свободу
Again,
саме
making a
через її
conclusion
внесок у
regarding a positive
автономність.
freedom, we shall first of all be guided by its contribution to the autonomy of a person. And now let's move from the autonomic category to current and modern technologies. There were already so many examples provided by regarding impact of AI and other technologies on the life and health of people. I categorize them into three categories. I mean, this impact I categorized into three categories, and they correspond to these three conditions of autonomy. And I just forgot to mention that this first condition, the availability of mental capacity of people, which allows them to be autonomic, it's actually fully correlated with Orwell's book. So it means that proles, they could be allowed to have freedom because they have no intellect. So they have freedom, but they don't have autonomy. They don't have autonomy because they don't have intellect. So if we take autonomy away from people, it means that then we can create some kind of regulatory framework for them, which will allow some freedom for them. Now we can take coercion as a method, but just use as manipulation. When proles have no intellect, they can be manipulated easily, as a pet dog, because a pet dog doesn't have such level of intellect as a person. And it could be related to any other pet which doesn't show high level of aggression, which could be brought up and manipulated and guided by such things. And in such a way, risks which intellect could pose to a different kind of powers and governments is just eliminated. So, tracks of impact on autonomy could be divided into three categories, and they correspond to three conditions, or better to say, to destroyal of those three conditions of autonomy. So, but they are given in a reversed way. So, targeted manipulations, they correspond to the third condition. The myth and ideological impact, they negatively impact on the first condition, that availability or presence of mental capacity of people, because applying and disseminating myths and other ideological impact, we decrease and destroy mental capacity of people. And the third impact, negative impact, that architecture and social norms, because such architecture and social norms, which are very narrow, could take the diversity, real diversity from us, which is related to the second condition. And then it leads to the fact that all of us, we're using the same servers, people or companies, developers of those servers, they are global monopolists, they are related to somehow to the states and powers which fight for their place to lead the world, and these are US, Russia, and China. So these are countries which fight for domination in this world. So de facto, the whole world is using servers which actually were originated specifically in these states. And it's not by accident, because those servers is an element of power. And we can see it when actually Trump has been fighting for so long time, trying to take control over TikTok and the USA. And it could be a question, why is it so? It's just an entertainment platform. No, it's not just entertainment. It's actually an element of power. So using such ideological impact methods, myths, and social platforms actually take diversity from people away, and we limit the list of options. Let's speak about such impact tracks in detail. So the first impact track is manipulation, and we clearly understand that internet ecosystem is based on very nuanced seasons manipulations. Manipulations are related to everything, different kind of feelings, design, vulnerable spots and states of people, and the most vulnerable categories of people are being manipulated the most, specifically those who are in the dire circumstances right now. One of the books which describes increase and outburst of different fake universities and higher educational facilities in US. And in US, they have several thousands of different universities, and half of them are just fake, which just gain some money. So those fake universities there, major part of their budget, and they actually contribute to marketing and advertisements, attracting people and to enter into these universities. So mainly those universities use online advertisement targeting vulnerable people, for example, former prisoners, single moms, and so on. People suffering from depression. So they do not receive this gain from rich people, but now they target poor people and vulnerable people. And they say that, oh, you are in poor condition right now, but enter our university and you will have access to different programs and you will receive some donations, some state benefits, grants, and so on. And it means that at the end of the day, those fake universities receive this money, and the owners, the leaders of those universities become US billionaires. And that's how this business scheme works. So we know the scheme. Just strange that it happens in the US, because we just get used that in the US that the education system, which actually shall be our target, our purpose to achieve. Yeah, but de facto, there are several hundreds of real good universities with high rankings, and thousands of those who are just fake and who provide nothing but gain everything. And actually, all developments of neuroscience are focused on development and improvement of such manipulations. So, internet and online companies, they have hundreds of billions of turnover. So for them, it's not a problem to funnel several billions of dollars to such studies, and it's not a problem for them. And in such a way, the studies which are being implemented in those companies, indeed, the level of studies could be much higher than in other academic facilities. They cooperate with scholars, but here the key purpose of the science being done there is only one: manipulations. If we scan internet looking for services suggested and provided to people. So if you have a product, you would like to advertise it, to promote it. So what services you can use? So there are so many different information services used by clients and or suggested to clients. They provide you information service to analyze your product, analyze your advertisement campaigns, and improve it in order to have a stronger impact on the final user. And that's a very good picture, which actually they show what people look first when they watch different videos, advertisement videos, how to boost ROI on A/B testing, how to use, what shall be used, what's your product, what's the button, what's the face, and so on. So if you look at the details, you could be overwhelmed or shocked. There was, for example, information in order to choose the link color, which is usually blue. They test 30 hues of the blue color. They then take a sample of people and they start clicking a link which has different 30 subcolors of blue, clicking and showing what will be actually the best one. So in order to increase the clickability of the link of final clients, and we have so many different things. Such manipulations have increased significantly, the same as the capacity of manipulations has increased significantly with the era of artificial intelligence. Because if AI is focused on human beings, they have no option at all apart of scrolling the TikTok TikTok all the time, specifically minors and people in dire circumstances which have less control over themselves, and they cannot go away from the TikTok. They cannot stop doing it. In such a way, manipulation starts doing the same function as coercion.
So in one of the works we read that the social media know about the consumer more than consumer knows about himself. It means that they can manipulate, they can make decision in a fraction of a second on these platforms dealing with this or that person. And the third element is the huge databases, including personal data, basing on which they develop patterns which are efficient in their influence on people. So if we consider this situation in this light, we should ask a question: are we clients or are we a resource? If we are clients, so there should be a certain equality between provider of goods and the client. There must be some horizontal civil relations where everyone is equal, but such relations doesn't function even in advertisement because platform dictates the policy and the advertiser can either use it or not, and there is no equality between the platform and the users of the platform because users don't know anything about the platform, about its algorithms. They are defenseless in the face of these manipulations and they have no choice. They can just stop using this platform, but if it's a world monopoly, there is no choice because everyone else is using that platform. I see that among my students, for example, there are some generations which use the same social networks, like 90% of them. Like the older generation uses one platform, the next generation uses some next platform. So we see some conformity, and it's very hard to stop doing that. Not everyone can do that. So what liberalism theorists say about that? Joseph Raz says that coercion and manipulation is the will of one person aimed against another, and manipulation is in the way of autonomy. Manipulation must be justified only by prevention of harm for autonomy. Isaiah Berlin says that all forms of games with people, bribery, or fitting their perception without their consent, influencing their thoughts and manipulation is against humanity. So the main goals here are dehumanization, and he wrote that long before internet and modern technologies existed. And now we realize how these technology influenced the manipulation of people. We see that on also in politics. For example, in Romania, an unknown candidate from the internet just in a couple of months gets to the first place in the presidential race. And it also happens in other countries where we see political instability. And now let's see at the next element of influence on autonomy. The first one was manipulation. The second one includes myths and ideology. When we speak about AI, we use words that are not very well fit for them. So the modern discourse includes such words as thinks, sees, understands, concludes, but actually it doesn't do that. These verbs, can be used for people and described either people or some live beings. The artificial intelligence doesn't do that. but we use these human terms for artificial intelligence. Even the word intellect is unfit, because if we take a dictionary and read the definition of the intellect, the most of that description doesn't fit artificial intelligence. Only about 20%, well, of this description may fit AI, but mostly it doesn't. But nevertheless, we call it, well, intelligence. So if we Google some news on AI, these news, let's say, well, are written in such a way as AI is something superhuman, some superhuman entity, or at least it has a potential to become a superhuman entity. So we have a new term, for example, AI hallucinations, when some algorithms used in the LLMs lead to false results just because of the nature of such algorithms. And we call it hallucinations, as if it has consciousness and it can be ill, as if there is some, well, personality. And if we Google pictures describing these hallucinations, it will be even worse if we look at these pictures which we have on this slide. Well, we can say that it looks like some demigods which transcended the human existence. So there are some myths in the society which existed long before computers and artificial intelligence. So the myths about the greatness of machine and the possibility of human race to create something greater, like God, some new life, some new sentient beings. But although these myths are, well, centuries or even millennia old, today we, well, are not at this point, and there are no evidence that we will reach that point in near future. Of course, the leaders of, well, tech companies who can use media, of course, they will say that the artificial intelligence is going to, well, rule the world. But we must ask, why do we think that these leaders of tech companies, these billionaires, why are they saying truth to us? If they're always telling the truth, they most probably wouldn't be billionaires. We can see that on example of Elon Musk, who said that repeatedly to move share prices of certain companies up or down to earn money. So they tell things which are, well, beneficial, profitable for them. So if we speak about the AI discourse, they say that AI should be strictly regulated, but why? For big companies to monopolize this sphere, this area, like they monopolized the market overall, and billions of people are their clients now. On the contrary, for example, Sidney Green, professor of robotics, says that modern AI or robotic system is still far less complex than the average bacterium, and it will do just what we want, and there is no mystery there. There is no will. It's much less complex than bacteria. But we are not big fans of bacteria, although bacteria are complex organisms able to survive, to evolve, to become human after evolution, because they have the same components as people. So we say that these bacteria evolve into human, so it has potential to evolve into human, but we are not captivated by bacteria. But we are fans of some things which has this myth of mystery and potential. So what are the consequences of that? Well, we can also read the words of Cindy Grimm about well, how we should speak about the AI. She says that we should use, well, such mechanical, strict language so that we won't, well, mislead people, we won't tell them, well, wrong things about the huge potential of AI. So such impression is necessary to sell these goods. Just imagine some product which doesn't work. Actually, most of the generative chats are not perfect. They have flaws, and they are not fit for many use cases. Sometimes, well, it's reasonable to use these chats, like you have to do some repetitive, monotonous work, and the artificial intelligence can, well, speed up that work. But in most cases, people use AI in inadequate and unfit way, like students during their education. Why do they do that? Because those who sell artificial intelligence tell these all things about the greatness of AI. There was information that new versions of ChatGPT, well, were not up to expectation, but billions were invested. And how you return that investment? You tell that it's perfect, the quality is the highest, so you increase sales, so it's just advertisement. So how these myths influence decision making? Here we have one of the recent studies in Nature, and in short words, it proves that people communicating with artificial intelligence, and when people know that it is AI, LLM, they trust it more than real people. And we can see that in the bottom right chart. So, if in the communication with artificial intelligence, it, well, proves the biases of that person starts believing these biases. It may deal with skin color, gender identification. So if in the conversation with artificial intelligence, and we know that it adapts to, well, a person, and if such person has some biases, they are, well, supported, this biases, this prejudice is supported by AI, and we don't see that in communication with other people. We have some biases, we have some prejudices, and we speak with our friend who also has such biases. In such case, there is no this reinforcement loop, because we know that this is a thought and it may be far from reality. But if we communicate with AI, with LLM, we believe that it was produced by some, well, great intelligence with great knowledge, and we trust it more. There was a myth previously, even before AI, that Google knows everything. If it's not on Google, it doesn't exist. And every scientist who does serious research, such scientists know that not everything can be Googled. Of course, Google, or especially first two pages of result, don't show what you really need. You must search, well, much harder in specialized databases, but still there is a prevalent myth that Google knows everything, and it was supported by Google itself. They had an advertisement campaign which said that we are the good force and we are trying our best not to be evil. We could be evil, but we avoid that path. So they speak about themselves in these mythological categories, which are, well, not very well fit for just a company on the market. And of course, advent of artificial intelligence even strengthened this myth, and it well, makes it harder for people to assess this market well adequately. And the third element of influence is the destruction of diversity. So this chart shows the use of words in articles, and we see that some words are used like 5 times more over recent 5 years. It means that other words which were used instead previously, they are, well, not used anymore. So if we see the situation that some words start to dominate, well, it changes the discourse. Next chart shows the number of articles using the phrase delving into. It was not used so often previously, but with the advent of these large language models, which are used to write texts, we see that the text became the same. So the first column here, 2024, is actually just the first half of 2024. So most probably there are 8,000 cases. So we see the exponential rise of usage of some words due to use of LLMs to edit texts. So we all kind of treat texts according to one parameter. Either it can be good or bad. So we ask LLM to improve the quality of the text, as if there can be better or worse text. But actually, everyone who writes text knows that there are a lot of criteria. If we analyze students' works, and there can be different student works, so if they wrote it themselves, we see that every work reflects the personality of the author. And now artificial intelligence is used to edit text, and in such way this diversity is killed. And if we start to consume such texts, which are poor in linguistic terms, so what results can we achieve? In one of the New York Times articles, it is compared with the pollution of culture. So this garbage generated by AI is polluting our culture, writes the article. And they quote Einstein. So if you want the children to be intelligent, read them fairy tales. And if you want them to be very intelligent, read them more fairy tales. But what happens when the toddler is fed with this garbage generated by AI systems? So what would happen with the consciousness of the children? So they call it synthetic garbage generated by AI, and we see lots of such garbage on the internet, and the pictures, graphics, materials on the social media, and they all look similar. And so if previously people used to paint, to draw, and the results were different, but AI will generate the same results for billions of users all over the world. But we actually don't know that it's the same, because we do not see the results which were produced for other people.
And at the end of my presentation, I would like to speak about legal acts. So everything what I have mentioned about individual autonomy. So everything is well known in the specific academic community, which guides and regulates AI and individual autonomy. So there are two documents which experts have developed in terms of the AI. And the first document is European Commission's high-level expert group's ethics guidelines for trustworthy AI. So let's say it in the following manner. So the strong side of this expert group is that it was independent from European Commission. The European Commission has established this expert group, and then it worked fully independently, because if it had worked as part of the European Union, then the results would have been absolutely different. But experts were fully independent. That's why they placed respect for human autonomy on the first place. They wrote that it's strongly associated with the right to human dignity and liberty. And they also have said that AI systems should not unjustifiably subordinate, coerce, deceive, manipulate, and so on people. So if you look into the details of those documents, we realize that the authors of this document fully understand the importance of individual autonomy and how AI threats it. And the second document, it's Montreal Declaration for Responsible AI. Also, key principles are formulated, and one of the principles, that's the principle of respect for autonomy. And its interpretation includes such an interesting formulation that governments and companies should not promote or discredit a certain conception of the good life, but they must empower citizens by ensuring access to relevant forms of knowledge, promoting the learning of fundamental skills, and encouraging the development of critical thinking. Again, here we can see that that's what I have just told you when I described this condition of autonomy related to mental capacity of a human being, which actually allows this person to be autonomic. So in the Montreal Declaration also we have this principle of individual autonomy, and it's mentioned that it mentioned that it's a fundamental principle and its fundamental value. And let's look at other acts which are not so great. For example, very well PR'd and promoted AI Act, which has been recently adopted by the European Union. So the high level expert commission has mentioned that autonomy is a fundamental value and it shall be protected. And the authors of the AI Act have referred to conclusions, to findings of this commission only twice in this act. In one, in the pre-word, and in another place. So autonomy is not mentioned anywhere else. Also twice in the pre-word to this act, and one of those references, that's a link or reference to this commission report. For example, Article 5, it's related to the following, that some AI systems are banned. For example, on this widely known pyramid, this is the red part on the top of it. So how it's formulated? Banned AI systems which deploy subliminal techniques. And at the end of this long sentence, what's else important? That it all shall cause significant harm to the person, another person, or a group of persons. So those two elements were criticized by experts, yet on the stage of the draft act development. So the draft of this act, when it was still under development, was strongly criticized by experts, because we don't know how to differentiate between subliminal and conscious techniques, and it's quite actually quite easy to prove that these are subliminal techniques, or they are not. So experts suggested to exclude this formulation, subliminal techniques. And another proposal of experts was to add societal harm, because as far as we understand, the key harm to the autonomy autonomy is correlated with harm to the society. So, in other words, societal harm.
Компаній чи держав, що вони призвели до втрати автономності
We'll never be
конкретної
able
людини.
to prove
що,
that some
як ми
acts
розуміємо, ця
or
автономність
actions
залежить
of
від
a state or an organization actually harmed in individual autonomy of a certain person, because we clearly understand that autonomy is impacted in the long term by different manipulations and so much. So in such case, it's almost impossible to prove this correlation between autonomy and actions of specific states or specific organizations. So it means that actually, if we don't have this societal harm, it nivelates provisions of this article in specific conditions when autonomy is under threat. What are the other layers of this pyramid? Do we have any other risks there? So maybe you will see it. So when we have high risk that the impact on health, security, and fundamental health, safety, or fundamental rights. So autonomy is not health, is not safety, and is not about fundamental rights, because the standard list and interpretation of human rights doesn't contain autonomy. So for us it's hard to protect autonomy using just a standard list of rights, human rights. That's why those who use such widespread and scaled manipulations, we cannot fight them back. Now, another level, transparency risk of impersonation, manipulation, or deception. And it's about transparency. And transparency requirement is the following: that AI content shall be labeled as the one produced by AI. In our case, it doesn't help at all, because in many specific cases, human being trusts AI content even more than content produced by other people. So yeah, if we label such content as the one produced by AI, yeah, maybe it will help to fight deepfakes, but it will not protect the autonomy. And it means that the whole text of this AI Act doesn't serve to protect autonomy, even despite of the fact that in many documents that had been developed before, it was clearly mentioned that autonomy under specific and higher risk when AI becomes on the table. So maybe then there's another question. If autonomy is not protected in the AI field, but maybe it's protected in other fields, another field which is very close and very important for the autonomy, that's information rights protection. And we understand that very often the regulation mechanism for this field is not effective or completely ineffective. And it means that it's based on the consent of people to use their personal data. And it doesn't work because people give this consent autonomic. No one reads the conditions, and even if they read it, there is no alternative option. In major part of the cases, provision of services is fully related to giving this consent. If you do not give your consent to share your information, to use your information, then you will not receive a service. And it's the EU understands it, and many scholars and academia understand it. What do they suggest? Using a managerial approach, they suggest to replace this ineffective mechanism of consent on processing of personal data on assessment of risk-based approach. So to assess risks between relations between businesses and governments. And yeah, it looks like it's not that bad. We have an ineffective mechanism, and maybe risk-based approach will be more effective. But if we evaluate this decision from the context of autonomy, then we'll have absolutely different vision. on that matter, because in the first option, the consent of to share your information, at least it includes some kind of an autonomic element. It gives a formal right to a person to agree or not agree. And the second solution actually fully exclude a person, and all these mechanisms of risk assessment usually they happen internally within one organization, and then it's being oversighted or controlled by the state, by the government. And in this concept, what's the place for autonomy of a human being? And there is no place envisaged for autonomy. And it means that we cannot make such conclusions that this solution is satisfactory because it does not foster and doesn't help to increase autonomy of a person. And also there are some other regulations which were adopted recently and which actually protect autonomy. All of us, we know the Convention of Council of Europe on AI, and these are all good news. So here in this convention, the autonomy concept is envisaged, and it's envisaged almost the same way as it's envisaged in the theory of the individual autonomy. And the Article 7, human dignity and individual autonomy, this principle, this article is put before all other principles. So it's de facto almost the first principle in the list. So individual autonomy sits the place near to the human dignity, and we know that human dignity is the key fundamental value of human rights. And they say that autonomy is an important element of human dignity. This convention differs from the theory of autonomy in such a way, because the theory says that autonomy is a foundation for human dignity. Here they say that that's a part, an element of human dignity, but in our case it doesn't make that much difference. And so they place a separate place, they give separate place for individual autonomy. And they think that it's a very important precondition for democracy, human rights, and the rule of law. And this convention also defines significant negative impact of AI on individual autonomy. So we can say that it's a very good foundation act. Of course, this convention is very short one, very small one. It doesn't have the relevant level of details, and it's not implemented on national level with different states, but it's better than nothing. So it's an international treaty which actually envisages human-centered approach and regulates the AI field, and which takes into consideration, first of all, human rights rather than interests of business and performance as the situation of the AI Act of the European Union. And to wrap up, I would like to quote Lewis Mumford, who is the author of the very famous book, The Myth of the Machine. And he wrote it back in 1970s, even despite of the fact that at that moment AI was far away from Lewis Mumford, but he managed to fail this everything what's happening in the legal field and the field of philosophy and moral, even despite of the fact that he dwelt upon more on the development of civilization. So 55 years ago, Mr. Mumford actually said that using this digital machine, the digital technologies, dominating minority will create such homogeneous or comprehensive super planet structure which is dedicated to automized work, and rather than actively functioning as autonomic human being, a person will become a passive, unintentional animal regulated by a machine. And also he says that privacy is a derivative from autonomy, and that autonomy becomes a precondition for being a human and being a subject, having an agency. And if there is no autonomy, a human being just becomes an machine-conditioned animal. So all the things which I have just mentioned, they are very well defined and underlined in Mr. Mumford's book. So our key task is to develop and adopt such regulations and develop such theories which will only strengthen individual autonomy and will help to protect it. Specifically, that we already have this foundation reflected in the Convention of the Council of Europe. Now we need to complement this foundation, this convention, with some details, with some other steps, and it will be a start for protection of individual autonomy. These are all absolutely new issues. Those topics have never been discussed before, and there will be different methods how to solve it. We have a huge field to actions, but the start has already been done. If you would like to learn more about this topic, you can read two articles which were written within this project. One of them has already been mentioned by Natalia in our monography, collective monography, and another of my articles it was also on the slide. So thank you so much for listening to me. Maybe you have some questions. Please, Vladislav, over to you.
Так, вибачте, у мене є одне
Yeah,
запитання.
sorry, I have
Скажіть,
one
будь ласка,
question.
чи
Please
зможемо
tell
ми
me.
ось майбутнє покоління
So
самостійно
our
навчити
future
мислити,
generation,
коли
will we
зараз
be
ми
able to
віддаємо
think
здатні,
independently
що цю
when
здатність на штучному інтелекту? Навіть
if we
розуміючи,
now
що він
delegate
не
this
ідеальний,
capacity
але
to
дуже швидко
AI?
розвивається.
So even in spite of the fact
Це
that
дуже
we
гарне
realize
питання.
that
У нас був
AI
захід
is not
про право
ideal,
бути
but it
забутим в
develops very
понеділок, і там теж
quickly.
задавали
Yeah,
питання,
you know, your
як
question is very
ці
good.
права
On Monday, we had
інформаційні
a forum
співвідносяться з
dedicated to
правами
right to be
майбутніх
forgotten, and
поколінь.
the same question was
Це
raised
гарне
there.
поєднання.
How
Тобто,
AI
знову ж
being
таки,
developed
про
right
права
now,
майбутніх
how the
поколінь ми говоримо
rights
лише
which you
в
have right
контексті
now
екології і
correspond to
ресурсів,
rights of our
а
future
напевно треба
generations.
говорити і в
Because
контексті
now we are
всіх
speaking about
інформаційних
rights of future
процесів.
generations only in
Дійсно,
the context
якщо
of
ми
natural
говоримо
resources
таки,
and
ну,
ecosystems,
постулюємо
but
культуру
maybe
і
we shall also
інформаційний
take into consideration
простір
this
таким
context of
сміттям,
information rights. Because if we
породженим штучним
garbage
інтелектом, то це
our
дійсно
information
унеможливить
space with such content produced by
виховання
AI, which is
творчої
actual waste, which is
особистості
actual
в
garbage,
майбутньому.
it will
Такі небезпеки вже відбуваються.
limit
От навіть
the
серед
creation
студентів я
of
це помічаю,
creative
що багато з них не відчувають
individuals.
різниці
Because
між
I already
таким
noticed
текстом
that
примітивним, сформованим штучним інтелектом
many of my
і
students
якимись
not
видатними роботами,
recognize, do
такими
not
на зразок, як того ж
differentiate
самого Міля чи Берліна.
some
Для
primitive
людини з
plain
якоюсь
text
класичною
produced by
освітою тут
AI
очевидна різниця.
and
Як писав Міль, і це
well-defined
просто захоплення викликає. Як
high-level
пише цей
texts written
штучний
by
інтелект, ну не
great
пише, а
scholars such as
створює,
Mill and
ну
others. Because
компілює якісь
so
свої там
for
фрази.
people of
Але
my
для багатьох
generation,
студентів це
it's easy
незрозуміло.
to
І коли я говорю
differentiate
читати
because an I just
дійсно якісь
compilates
праці важливі
some sentences
і
and
які
so on. And
пройшли
when I say that
випробування
it's important to
історією,
read some
а не читати от щось таке,
important
ну,
articles,
скажімо,
important publications
з
which have been
якогось
already
сіюминутне,
tested
так,
and
то
by
тоді, якщо все одно
by
багато схиляється
historical
до того,
times
щоб
and
взяти
proven
те,
that
що
they are
лежить на
valid. But
поверхні.
many of
Ввести в
them
Google, а Google ще й
prefer and
підсуне
opt for
цей
to
результат
choose
штучного інтелекту
to
наверх.
choose
Мабуть, треба
something
робити певне
laying on the
випадання з
superficial. They
цифрового
just go
простору,
to the
брати
Google and
паперову
Google
книгу,
suggests them what?
якусь вартісну,
Just
яка
AI
стосується якраз оцих таких політичних
produced
питань.
content. So maybe you
Якісь
shall take
відомих
not
філософів
online
минулого, і
texts but
тоді
paper
з'явиться оце
ones,
розуміння,
those
чому їхній рівень є
a
в
book
порівнянні
of some
вищим, ніж рівень того, що продукується
past
зараз. І, до речі,
philosophers,
навіть
and you
оця
will
книга
compare. You
Мамфорда,
will see
якщо її
even this
почитати,
Mumford's book.
книга
If we
70-х років, то
look at
зразу
it,
видно теорію, його
so
рівень
that's if you
розуміння
compare it,
цивілізації,
and
ніж багатьох
what's his level? His level of
сучасних книжок на
understanding
зразок
of
там Юваля
the
Ноя Гарарі.
civilization. If you
Тобто
compare it
деградація,
with the
вона не
current books,
лише
current
в сфері
authors,
верховенства
degradation
права,
happens
але
not
мені
only
здається, що
in the
вона
rule
і
of
в
law, but
інтелектуальній
I
сфері
think
також
it also
присутня.
happens in the intellectual field.
Чи є ще якісь запитання?
Are there any other questions?
Are there
Прошу,
any
пане Анатолій.
questions more? Please, Mr. Anatoly. I don't see in the chat we have a word question, and now I see. So which program should we use to? So the question is being typed in the chat, but in the meanwhile, you can ask another question if you have some.
За цей час, поки, можливо, з'являться ще якісь запитання, я скину у чат
So if we have more questions, and in the meanwhile, I will send some documents prepared in the framework of our project action plan on legislation reform in IT sphere in the light of AI threats, and we offer all participants of this event to look through these plans and propose your comments or additions. You can do that in person now. Just tell us about your proposals, or you can send it via email to Yulia Razmetaeva, to the project. We will systematize these proposals in order to make our discussions not only nice discussions, but having some concrete recommendations for business, for authority in the various spheres. So we have two plans. The first one deals with improvement of Ukrainian legal system in terms of issues arising from global digitalization, and another plan, action plan on improvement of Ukrainian legislation, legal and business practice in terms of issues arising from global digitalization. So I invite you all to look through these action plans, and maybe you will have some thoughts how to improve these plans and take into account some maybe other aspects which should be taken into account when we speak about creation of new legal acts. So now I will try to answer the question of Mr. Anatoly, how distinguish thoughts of prominent scientists from primitive AI materials. Well, here probably nothing will help but high quality education in the humanities and social sciences. If you have such education, you can distinguish them easily. So if we speak about some practical disciplines, technical disciplines, economics, so it's rather hard to make such distinction. So high quality education, well, the quality of education is another tricky issue, but the complex education is important. So let's ask ourselves a question. Why, when totalitarian authority comes into power, why do they destroy humanities scientists first of all, while technical specialists can adapt? Of course, there were specific cases, and technical scientists were also persecuted, but less, because totalitarian regime wants to destroy autonomy, which is rooted in culture and in humanities. So the more a person is rooted in the humanitarian sphere, in culture, the more the person gets immunity from manipulations and can distinguish quality text from useless text. So if you, I would recommend you to read some long works, complex texts. You can also use, experience of theater, exhibitions. This art sphere allows to get digital detox, to leave this manipulation bubble and have some other experiences. And using such contrasts, you can have fresh view. So another question, what do we do with the use of personal data? Can we avoid that? Can we reject that? Because often people have no choice. Actually, there is an option like to change settings of your smartphone to have operational system free from surveillance. It can be done on Google Pixel phones. You can use, well, so to say, clean Android OS. Well, there are some ways. They are described in the sources, but these solutions are complex, difficult, and connected with some inconveniences. You have to, well, make some efforts to implement such solutions. So it is done only by people who really are afraid of some surveillance which can be used against them. And for ordinary people, such option doesn't look too attractive. Of course, you can change privacy settings on your smartphones, but there will be updates of software with another default options, which well, lead to maximum surveillance. And besides, now AI is introduced to most of the software on the smartphones, and there are predictions that we will not be able to use Google services in the near future without allowing it access to contents of our smartphone. It's partially implemented in some high-end smartphones already, so there is some movement in this direction. Maybe the life in digital world and outside of it balance will help to deal with that. I believe that living the digital bubble is a successful strategy. So you can have a couple of hours detox, you can go outside, you can go for a walk without your digital devices. So you can, well, leave this system and it won't influence you so powerfully and won't be integrated in your thoughts so much. Well, there are no absolute solutions because the autonomy level is going down with each year because of this huge machine built by these big companies and state authorities. And here we can also add that autonomy is not, well, good or beneficial for companies and state. Their goals are to improve the efficiency of management and control, and so they reduce people to single units which are predictable and can be directed in this or that way. And it is further supported by the fact that, well, such benign systems as, say, EU have to compete with not so benign systems like China. And, well, we know that in China, it is prohibited to write negative comments in social networks, so everyone must be happy. Well, it starts to look like dystopia, but at the same time, they're efficient in their economy, and EU cannot lag behind. They want to show efficiency also in technology, in competitiveness and business. So this race makes the benign political actors to also move towards reducing autonomy of people to get to efficiency. So the situation is not too bright, but the expert community is ready for these decisions which are needed. People who work with human rights start to prepare some documents. So maybe in the coming years there will be some shift, and this movement which we see in this direction which we see today will be changed. So we have positive examples like this Council of Europe Convention. We can adapt a law implementing the provisions of these conventions in Ukraine. We can show good example of adequate regulation. Dear colleagues, I will continue my moderator function, and I thank Mr. Petro Sukharolsky for moderating the first part of our today's events, and we are grateful to him for that, and also for his detailed speech dedicated to digital rights. So thank you, Mr. Petro, and we continue our work, and I'm glad to present the next speaker, Andriy Hachkevich. Mr. Andriy is PhD in law, associate professor of Department of Criminal Law at National University Lviv Polytechnical Institute, and he is author of various publications on legal topics and influence of AI on this sphere. He is an expert of National Agency of Quality of Education, and he is author of multiple programs, educational programs in specialty IT technologies. And I give you the floor, Mr. Andriy. Good morning, Ms. Natalia. Good morning, dear colleagues. Thank you for the possibility to speak. And I have a couple of words to greet our foreign colleagues.
My report, it is dedicated to the processing of personal data by AI systems, and it is based on the activities of supervisory authorities, especially of the EU countries. My name is Andriy Hachkevich. I represent Lviv Polytechnic National University, and I work as an associate professor at the Department of International and Criminal Law. My research area of interest is human rights and modern technologies. First of all, first and the foremost, artificial intelligence.
Я перепрошую, трошки вас переб'ю, навіть не переб'ю, а
Well,
трошки
I'm sorry, I will intervene a little bit.
Which I can see have already joined our Zoom meeting today. I would like to say that we have a synchronous translation today, as we used to have yesterday. So to choose the language which you prefer listening, you can turn on the button, below the Zoom window, and you can see the globe button where you can see the word translation or whatever word you use in your national language, and you can switch the language option here. In fact, we have two options today. This is either Ukrainian or English version. So enjoy any language you choose. I think that it might work okay. At least we checked this option today, and everything worked okay. So feel free to choose any language version you prefer. Okay, пане Андрію, продовжуйте, вибачте.
So, Mr. Andriy, please continue. Sorry for interrupting. Okay, so before starting my presentation, I want to thank the organizers of this great event, Mr. Petro Mikhailovich, who invited me to participate, Yulia for her great feedback, and Natalia for helping me being well understood by the audience who doesn't speak Ukrainian.
Тематика
So the
мого
topic of
виступу
my
присвячена проблемі
speech is
захисту
issue
персональних
of
даних при
protection
обробці
of
системами
personal
штучного
data
інтелекту.
during processing by AI
І
systems.
за основу
And
я
the
взяв
basis for this
діяльність
research is
наглядових органів захисту
activity of
даних,
supervisory
насамперед
authorities
держав-учасниць
for data
Європейського Союзу.
protection, first of
Чому
all,
ця
member
тема
states of the
викликала мій
EU.
інтерес
Why
і
this topic
чому
attracted
я
my attention and why did
провів
I
дослідження?
well do
По-перше,
this research?
для мене
First of all, for me,
було важливим
it was
зрозуміти,
important to understand
як саме наглядові
how
органи
the
реагують
supervisory
на
authorities
використання
react
систем
to
штучного
use
інтелекту
of AI
і
systems
які саме
and
порушення вони
what
вбачають у такому використанні
violations they
особих
see
персональних даних.
in such
Безумовно,
usage in
наглядові
terms of
органи
personal
є
data.
свого роду
Of
такими
course,
гейткіперами,
supervisory
фасттрекерами
authorities
для
are, well,
того, щоб контролювати
scrutinizing
ці процеси.
and controlling
І
these
в
processes.
таких державах,
And
як
in such
Іспанія,
states like
Італія чи
Spain,
навіть Франція,
Italy, or
ці
even
наглядові
France,
органи дуже
the supervisory
ретельно і дуже
authorities, well,
детально вивчають все те, що
study
відбувається з персональними
very
даними
closely
навколо.
everything which
Тому, на мою
happens with
думку,
personal
їхня
data.
оцінка
So
дає
their
можливість
assessment
нам
allows
зрозуміти
us
краще
to
ті основні
understand
проблеми, які
better the
сьогодні
basic
виникають з
problems
персональними
which
даними
arise in terms
у
of
зв'язку з
personal
штучною розробкою
data
штучним
in
інтелектом.
connection with their processing by AI.
По-друге,
Secondly,
важливе питання сьогодні
the
стосується
important
ризиків
issue
і тих
today
викликів,
deals with
які
risks and
породжують
challenges
сучасні системи
which
штучного
arise
інтелекту.
from the
Ці системи
modern
стали
AI
широко
systems.
вживані, і
These
з кожним
systems are
днем
widely
їхня
used
популярність зростає,
and their
і вони
popularity grows
використовуються
and they are
все
used
більше і
more and
більше.
more.
У своїй доповіді я
In my
згадаю про
speech,
деякі
I
з таких
will
додатків,
talk about such
ми
applications,
зможемо побачити,
and
що
we'll be able
це
to
ті
see
додатки,
that these
які
are the
сьогодні знає
applications
кожна людина,
known
зокрема
to
чат
everybody today,
GPT.
like
Тобто
ChatGPT.
ця тематика
So
дає
this
можливість зрозуміти краще,
topic
в
allows
чому
us to
полягає
better
небезпека
understand
систем штучного
the
інтелекту
essence
і
of
як
danger which
ними
arises from
користуватися,
AI
щоб
systems and how to use
захищати
them to protect
свою персональну
your
інформацію.
personal data.
По-третє,
Thirdly,
діяльність наглядових органів захисту
the
даних
work of
чудово
supervisory
показує
authorities,
особливості
data
цікавого
protection
застосування
supervisory authorities
законодавства,
show
яке
us the
стосується захисту
specificities
персональних
of
даних.
application of
Як нам відомо,
legislation in
GDPR,
sphere
Закон
of
України
personal
про
data
захист
protection.
персональних
So
даних
as we
і
know,
інші основні
GDPR,
документи
the law in
мають
Ukraine on
відповідно
personal
зареєстрований
data
світ.
protection and other
Я
legal
вже не
acts
кажу про
adopted
Конвенцію
in
Ради
various
Європи. Вони
states
були прийняті
of
задовго до того,
world,
як
not forgetting
з'явився
the
чат
Council of
GPT
Europe
і
Convention. They
сучасні
were
системи
adopted
штучного
before
інтелекту. І
the
правила, які лежать в основі
ChatGPT
цих
or
документів,
modern AI systems.
вони
And the rules,
формувалися раніше,
which are in the
ніж
basis of these
ці
documents,
системи
were formed
створювалися, і
before the
вони
creation
були
of such
введені
systems and
до
were
вжитку.
introduced
І
in
тому
everyday use.
дуже важливо
So
розуміти,
it's
як
important to understand
застосовувати ці
how
норми
should we
і
use
як
and apply these
адаптувати
norms and how to
положення, які
adapt
були
these
прийняті
provisions
до
adopted
прийняття
before
до створення систем штучного
creation of
інтелекту до
artificial
тих умов, в
intelligence
яких ми
systems,
живемо сьогодні.
how to adapt to
І
modern
ще один
conditions.
момент, який
And
мене
another point,
переконав все ж таки
which,
обрати цю тему
well,
дослідження
showed me
і
that this
провести
topic is interesting
вивчення матеріалів,
and I
це
should
те, що
study
в
these
Україні
materials,
стан
well,
захисту
it's the
персональних даних
fact that in
поступово
Ukraine
кращало,
the
і
personal data
відсутність
protection
розвиненої
is not
системи
perfect.
інституцій для
There
нагляду
is
за захистом
no
персональних
system
даних,
of
так само
institutions
недосконале
for
законодавство.
data protection which is
Це
well
ті
developed.
проблеми, які
The
сьогодні нам
legislation is not
помічені.
perfect.
І
So
я
these are the
сподіваюся, що
problems which
моя
should be
доповідь
noted today, and I hope that my
доповідь
speech
інших
and the
учасниць
speeches of other
і
participants
взагалі наш
and
понад
the
свідомо
forum
ще
as a
раз і ще
whole
раз підкреслять те,
will
що
emphasize
захист персональних даних
the
в
fact that
контексті
personal
штучного
data
інтелекту
protection in
це
context
одна з
of
найбільш
artificial
гострих
intelligence
проблем,
is one
які
of the
пов'язані
most
з сучасними
urgent
технологіями
issues of modern technologies today.
Суть мого дослідження
So
полягає в тому,
the
що я спершу
essence of
здійснив
my
пошуки
research
інформації про
is in the following.
реагування
I searched for the information on how national data protection supervisory authorities react to the use of AI systems, and I analyzed their possible feedbacks. Overall, I managed to find information on more than 40 states. These are not only states of European Union, but also the supervisory authorities are active in Latin America, in Asia. So, and on these 40 states cases, I saw that attention is paid to the same issues and services based on artificial intelligence.
В першу чергу мені були цікаві рішення, які були винесені вже
First
після
of all, I was
проведених
interested
розслідувань.
in
Але крім
the
рішень, я
decisions
знайшов і масу інших цікавих
made
джерел,
after investigation
які
carried out, but
надходили від
apart of this,
наглядових
I have
органів.
also found quite an
Скажімо,
interesting source of
наглядовий орган
information.
Люксембургу навіть видав
For
свої
example,
рекомендації, які
information received from
стосуються використання
oversight
сервісу DeepSeek
boards.
у
For example,
Люксембурзі.
Luxembourg
Деякі
oversight
наглядові
board
органи
issued a very interesting
проводили
decision on using
консультації,
of
давали
DeepSeek
рекомендації конкретним
and
компаніям, але так і
DeepSeek
не виносили
and
рішення
some
проти
oversight
них.
boards provided
Тобто
some
саме
recommendations and
розслідування не
carried
завершилося
out
тим,
some
що було
investigations, but
прийнято
without
якісь
solid
санкції і
conclusions
запроваджено
or
штраф.
sanctions applied
Андрій,
regarding this
перепрошую,
or
скажіть,
that
будь ласка, у
company.
нас слайд зараз
Dear
ми бачимо
Andrei,
слайд
I'm
2.
sorry to interrupt
Чи
you,
все
but we
правильно?
see
Так,
right
все
now on
добре.
the slide 2.
Я
Is
перепрошую,
it
я на
that
всякий
right?
випадок, бо
Yeah,
бувають прикрі
yeah.
історії,
Just in case asking,
спікер
because you know there could
переключає себе
come
слайд,
such
а він
stories
чомусь не
when
переключається. На всякий
slides
випадок.
are
Давайте
frozen and
спробуємо
they are not
зараз цю
clickable. Okay, let's
процедуру
try.
зробити.
Let's
Так,
try.
Все гаразд.
Yeah, all is
Так.
good. All is good. We
Дякую,
can
пані
see slide
Наталя.
number 3. Thank you.
Дуже слушно, ви підказали,
Yeah,
що час
indeed.
перейти
Thank
до
you.
плану виступу і коротенько
Now let's move to the agenda
представити
of my
ті
presentation and
питання, на які
present to
сьогодні я
you
хочу зупинитися.
those issues which I will
Я
cover
хочу
in it.
показати, що таке обробка
So first of
даних
all, I
як
would like to share
поняття
what
і
data
в чому
processing
полягає
is as a
її
concept
взаємозв'язок
and
з
how it's
використанням штучного інтелекту.
interconnected with the usage of
Адже,
AI.
як я вже сказав,
As I have
законодавство
already
про обробку
mentioned,
даних, про персональні
legislation
дані, воно
on
виникло
personal
перед тим,
data
як
and data
системи штучного
processing had
інтелекту
been
стали
developed
дуже широко
before
вживаними,
the
особливо наративні
widespread
системи
usage of
штучного
AI,
інтелекту.
specifically generative
Наступне
AI
питання
systems.
стосується
The
способів
next part of
обробки
my presentation
штучним
will be
інтелектом
dedicated to
персональних
methods
даних,
of AI
і я
processing of
зупинюся
personal data.
на
And here
таких
I will
приблизно
focus
5 способах,
on those
які сьогодні
5
дуже поширені, і
methods which
покажу,
are quite
як кожен
widespread
з цих
nowadays, and
способів
will show how each
стосується
of these
обробки
methods
персональних даних. Тобто, що
is
робиться з
related
персональними
to
даними тоді,
personal
коли
data
штучний
processing.
інтелект
So I will
працює
show to you
таким
what
чи інакшим
actually
чином.
will happen to your
Кілька
data when
кейсів
it's
я
being
також
processed by
представлю,
AI.
і це буде
I
не
will
тільки
present to
кейс,
you
який
also
має
some case
відношення до
studies, and
італійського наглядового органу
there will be
Гаранте
not
та
only a case
чату
dedicated to
GPT.
Italian
І на завершення я
Garante
узагальню види
oversight
порушень
board
і
and GPT chat, but also some other
визначу, які
cases. And
саме
the last part
найголовніші
of my presentation
претензії
will be
були
dedicated
у
to types of
наглядових органів
violations and
захисту
what were
даних
key
стосовно
concerns
того,
of
як
the
штучний
data
інтелект обробляє
protection
персональні
regulating authorities
дані.
in terms of how AI treats and processes AI,
Власне, наглядові органи
personal data.
Європейського Союзу,
So,
діяльність яких
regulating
базується на
authorities
статтях
of the EU,
55-58
which
Загального
are
регламенту про захист даних,
covered
це
by
свого роду
Article 55,
золотий
58
стандарт
of the
в
GDPR
універсальному
Act.
контексті.
And
Адже
GDPR
ті
Act is
органи, які були
actually a
створені на
golden
інших
standard in
континентах,
the
вони
universal
десь в
context
чомусь
because
були
some
створені
other
саме такими
regulating
самими
authorities
європейських органами, а
established in
відповідні
other
національні
countries and other
документи захисту
continents,
GDPR.
they used
Можливо, одним з винятків
European
в цьому плані
model
є
as,
Сполучені Штати
as an
Америки,
example.
де існує
Um,
своя достатньо
there is another
складна
example of the
система захисту
USA
персональних
where they have
даних, і
their
такого
own
єдиного
comprehensive,
органу,
quite
як в європейських
sophisticated
державах, не
system
існує. Так
of
само цікавим є
data
випадок
protection regulating authorities, and they do
інших
not have a
федеративних
single
держав, зокрема
body as in
Німеччини,
the EU.
чи
Now, also other national examples as Germany, Canada, or Australia, where certain subjects of federation could have their own, could have their units which will work on data protection. And Germany is quite an exemplary case here, where some lands and federation subjects have their own regulating authorities, and their decisions and their recommendations shall be definitely taken into account when you study this topic. During my investigation, I have also identified around 10, maybe 15 AI services which raise the most concerns of regulating authorities. And of course, because of the lack of time, I will not be able to present all those organizations, the regulating authorities, and their concerns to you, but I will mainly focus my attention on Clearview AI. That's service which was developed based on the photo pool of individual persons, and those photos were collected from the internet and they were publicly accessible. Part of the photos was collected from the Facebook social network. Then the photo database was created, and then a comparative analysis could be done. So to compare those photos existing in this database and with other new photos, and to identify people. And of course, it's clear that Clearview AI, it's not just about some new opportunities or new services for some users or companies, but no, it gives very strong advantages for law enforcement, and those in comparison with those law enforcement agencies which do not use such methods. And that's the issue, whether you can use AI and Clearview AI to identify persons with, for the sake of some law enforcement purposes. It was always under the table, under discussion, and there are different pros and cons regarding it. Another service which also raised concerns of regulating authorities is ChatGPT, and which I have already been mentioned before. And here, first of all, we are speaking a case of Italian regulating authority versus the GPT chat, and it has already issued some sanctions against it, and I will develop on this case later. And according to regulating authorities, usually it raises some typical challenges and concerns for different regulating authorities. And the third service, and the reason why actually I opted for it, it's because for the last year, this third service raised significant concerns from a huge number of different regulating authorities, not only in Europe, but also in other continents, even in countries which are neighbors to China. And here I'm speaking about DeepSeek, which is actually very similar to ChatGPT. It's also a generative talking chatbot, but when it was launched, the developers have made very sensational announcement that the net worth of DeepSeek is absolutely different from ChatGPT, but its options available for clients are much bigger, and it offers much more opportunities to clients in comparison with ChatGPT. But at the same time, the DeepSeek itself and the fact that it's owned by China raises significant concerns whether the data is protected at all, and whether the system could be trusted, whether it could be used not only by private users but also by public authorities. because, yeah, indeed, it attracts so much for offering different benefits, and it shows quite significant enterprising results. But at the same time, not just conversational chatbots and photo identification tools raised concerns from the side of regulating authorities. And I would like to mention other examples. And first of all, that's the Be Digital AI company, which was under investigation of the Spanish regulating authority. This company is famous with the fact that they developed software, AI-based software, which allows to process different written documents such as emails and letters, extract some data from it, and using it then generate new documents using different sets of data. There are also some two other cases which are definitely related to the topic of AI, even despite of the fact that investigation itself themselves didn't cover the application of AI, but anyway, they were related. So that's Equifax case. Equifax, that's a very famous company, which also was under investigation carried out by the Spanish regulating authority, because there were concerns raised regarding appropriate level of personal data protection and regarding the fact that information received by this company is collected from the internet without receiving consent from users, and even despite of the fact that this information is publicly available. Anyway, to opinion of plaintiffs, this information shall not be used in such a free manner. Equifax had no legal rights, even for the sake of purposes to identify credit capacity and credit history of a person. And in another case, that's based on the French court precedents. It's also it's related to Amazon and Google cookies policies. It's not directly related to AI, but anyway, it's adjacent to it. So the claims were the following. The cookies policies of these two companies were not well regulated and defined, and in such formulation, users do not understand what will be next done with their personal data by these companies, including usage by these companies of AI. So processing of personal data, that's quite a varied topic. It covers so many different processes related to personal data. These processes these processes are envisaged in the General Regulation on Protection of Personal Data of the European Union. And I would like to classify these processes. The classification you will see on the next slide, on this slide. And to my opinion, you need to divide the whole process into 4 categories, such as collection, use, change in quality, and deletion. So generally speaking, I have communicated with many people. Major part of them have such an assumption, such a thought that usage of personal data happens only when something is being done to this data. For example, when this data is used to create a document, or when these data are somehow transformed into another set of data. But the general regulation on data protection and the law of Ukraine on protection of personal data and the laws and acts of other countries tell us that that's wrong position, but data processing includes also data collection and includes also data deletion. And as we know from many publications of Ukrainian scholars, including Petro Mikhailovich, that he writes to be forgotten or right to delete personal data, and that's a very important right in the field of personal data. Each person has a right to be forgotten in the context of information available about themselves in the internet. That's why I have categorized those four categories. So not only collection, use, and deletion, but also change in quality. I think that it's a very important category of data related to AI. Yeah, maybe it's not so obvious from the first glance, but anyway, it's important in terms of the total process and what happens with the data. So what can be done in terms of data collection and in terms of change in quality? So on the one hand, personal data can be corrected, thereby becoming more accurate. It can be encrypted. And there are some types of encryption when AI changes part of the personal data and gives them some new titles or names. Just to give you a practical example, when the surname of a person is encrypted and it's presented in a kind of a cipher, which is known only to the AI, and in comparison with pseudonymization, this cipher cannot be deciphered or unwinded backwards. And another example of the change in quality is related to different automized processes. When some data could lose its accuracy during this process. Another example, which is very interesting, where as far as I understand, that's ongoing case, and we know only about complaint which has already been submitted, and it's in Norway, and in Norwegian regulating authority will carry out some investigation. So the case details are the following. Norwegian citizen registered in, so actually placed in the internet information about who he is, and conversational chatbot provided resume, so wrap-up information that actually that this is a very this is a perpetrator, and he's notorious perpetrator. He killed his two children, his wife, and so on, and it caused an outburst of attention in the society. And actually, it's not a single case. There are at least five cases when different people ask information about themselves in the from the artificial intelligence, and AI provided them with information about themselves which was absolutely incorrect, and they saw it not only as violation of their personal data protection right, but also as a threat to themselves, as a threat to their dignity. There was another case, very interesting case here of a journalist. A journalist asked a question about himself from a chat GPT, and this chat.
Перепрошую, пані Маргарита, виключіть, будь ласка,
Sorry, dear Marina, please mute yourselves.
І одну секундочку. Пане Владиславе, технічна підтримка. Виключіть, будь ласка, мікрофон для всіх слухачів, крім Андрія Гачкевича.
Yeah, technical specialist, please help us mute our listeners. Thank you. Thank you, Natalia, for your help and giving an opportunity to continue my presentation. Now all is good, I can continue. So one more interesting example, Andrei. One German journalist asked the same. So he asked ChatGPT who he is, and the ChatGPT answered that he is perpetrator, and he started listing different types of crimes allegedly committed, or so to say committed by this journalist. But actually, in reality, those crimes were not committed by the journalist, by he described those crimes committed by other people in his articles, but ChatGPT interpreted it in a wrong way. That's all about change in quality, which happen because because of intervention of AI. And those changes in quality could be both negative and positive. And when AI, for example, helps to decrease the sensitivity level and helps data to be less applicable to committing some different
Які способи
violations.
обробки
So
даних штучним інтелектом сьогодні є поширені, і
what are
як вони
different
стосуються самого поняття
what
обробки
are different
паперової
methods of AI processing
найвідоміший
and how
спосіб
they are
обробки,
related to
про
data processing
який,
in general.
мабуть,
The most
найбільше сьогодні
common
згадано у
data processing,
рішеннях наглядових органів, це
which is
навчання систем
widely
штучного
mentioned in
інтелекту.
different regulating authorities,
Йдеться
it's
про те, що
training
системи
AI
штучного
systems. What we are talking
інтелекту
about here? I mean
використовують
the
ту
following, that
інформацію, яку вони
AI
отримують, для
systems
того, щоб
use
знаходити
data
певні
received in
закономірності
order
і
to
шаблони,
identify
і в
some
подальшому на основі цих закономірностей і
similar things,
шаблонів
trends, patterns, and
виконувати
some
ті завдання, які для них
other
поклали.
similarities in order to fulfill
Навчання
tasks
систем штучного
put on them.
інтелекту з одного
Training
боку
of AI
вважається
systems from one
діяльністю
side is considered
некомерційною
to be
і
non-commercial
безпечною,
activity
адже
and safe
інформація,
activity,
яку
as
нібито штучний інтелект
information
застосовує для того, щоб
used
навчитися
by
краще
AI
виконувати свої
in
завдання,
order to
потім нікому не
perform its
розголошується,
tasks
і стосовно
better,
неї
never
можна бути
is never
спокійним.
being disclosed
Разом з тим,
disclosed
позиція
further,
наглядових
and you
органів є
can be
достатньо чіткою
safe
в
and
тому
sure
плані,
about
що
it.
навіть для
But at the
навчання
same
має
time,
бути
there's a
певна
very
підстава.
certain
І
position that
навчання
even to
має
carry out
відбуватися
training for
згідно
AI,
з правилами
there should be
загального регламенту про
there
захист
should be
даних.
some rules applied, and the general
Зараз
regulation on data protection
у
provision shall
розмовних
be applied.
чат-ботах мала би бути така
And
опція,
now
що
conversational chatbots should
користувач
have some
дає згоду на те, щоб вся інформація, яка стала
should
відома
apply some
з
rules
розмовного
that
чат-боту під час взаємодії,
user shall
була
provide
використана
consent
для
to
навчання цієї
for their
системи
personal
штучного
data
інтелекту.
received by the chatbot during
Тобто
interaction to
наглядові органи виходять з позиції, що
for
навіть для
training of AI
навчання
systems. So it
має
means that
бути
regulating
правова
authorities
підстава.
think that even
І найпростіше отримати
training of
таку
AI
правову
systems
підставу
require
через
some legal preconditions. And
згоду
the
самого
easiest
суб'єкта.
way to receive such legal preconditions through the consent
Водночас
of a
я, на жаль,
user.
не знайшов деталізації стосовно того, які
At the same
саме
time, I wasn't able to
конкретні
find the
деталізовані процеси
detailed
лежать в
description
основі
of the
навчання.
processes lying in the
Тобто
basis of
наразі
training.
сама суть
So
навчання
currently, the
обробки
nature of the
обробки
training
персональних
in
даних
terms
не
of
є дуже
personal data
деталізована,
processing is
і,
not
як на мене,
very
то
detailed.
з цим
And
потрібно в подальшому
I think
працювати.
that we
Я, до
must
речі, хочу
work
відразу
with
зазначити
this in the
одну з
future.
проблем,
And
яку
I
я теж
also would like to draw
відзначив
your
для свого
attention to one of the
дослідження. Вона полягає в
problems
тому, що оцей
which
перелік
I
способів
highlighted in my
обробки,
research.
який я вам
And
показав на попередньому слайді,
the
багато
list
пунктів з
of
нього,
the
вони
processing
також
methods
не
shown
є
on the previous slide
конкретизованими
are not
як процеси
detailed
по
as the
відношенню до систем
processes
штучного
in
інтелекту.
the context of AI
Тобто
systems, so that
достеменно невідомо,
it
як
is
сприймати
not
кожен
known
із цих способів
exactly
обробки
how these
в контексті
data
штучного
processing
інтелекту.
methods
І тут,
are
безумовно, потрібні якісь
understood in
роз'яснення,
terms
які
of AI.
стосуються цих
So some
понять. Тим більше, коли я
clarifications
аналізував
are
законодавство
needed
інших держав,
here.
не тільки
When I
держав
analyzed
ЄС,
legislation of
тих
other
держав,
states, not
які,
only from
звісно, що
EU,
не базують на GDPR, то я побачив, що
and
в них
those states
зустрічаються і
whose
інші способи
legislation
обробки,
is
які
not
є
based on GDPR, I found that
взагалі
there are
можуть бути
other
незрозумілі,
ways of data
і,
processing
власне,
which can be
потрібно приділити увагу тому,
unclear,
щоб
and
ці способи обробки в
some
подальшому
attention must
конкретизувати
be,
і їх
well,
зміст
devoted
роз'яснити
to
відповідно до
making them
тих
more
можливостей, які сьогодні дають
concrete
системи
and
штучного
explained in
інтелекту.
terms of the modern
От.
capabilities of AI systems.
Другий момент і
So the
другий
next
спосіб
point
обробки
and the
інтелекту
next
персональних даних
way of
відношення
personal
до
data processing by
використання
AI
чат-ботів
deals
і
with chatbots
відповідно
and their
процесів
interaction with
скористання.
users.
Виявляється,
So
що деякі наглядові органи
some
вважають
supervisory
відповідність
authorities
користувачем окремим
treat
способом обробки персональних даних і
work with users, they treat work with users as a separate way of personal data processing. And for it to happen, there should be a legal basis. So this way differs from AI systems training, although, well, they are not mutually exclusive. When data is collected, it can be collected both for training and for future interaction with the user. But how it looks in real practice? In the first case, data is collected for the system to function better. Well, without, well, some specific connection to user. And in the second case, specific user must get the best feedback possible because the artificial intelligence knows the user and is able to interact efficiently with the user. And I believe that if we scrutinize this issue, I guess that supervisory authority should demand companies to ask users' consent not only for AI system training, but also for the interaction of the system with user, because these operations are different, they have different goals, and we must say that we should ask a separate consent for each of the operations. The next way of processing is data encryption. I've already mentioned that and demonstrated that AI systems can be valuable in terms of making data less sensitive, in terms of anonymization and ability to use data with less risk and with new opportunities. The next point, well, includes marketing objectives, and that's another separate field of research, especially in foreign studies. Here we can mention targeting, profiling, and such processes where with use of AI, the data on behavior of the user in the internet and social media is collected, and conclusions are made about his interests, about advertisement that could be shown to such user, and later the AI system directs the processes in such a way that to demonstrate advertisement to such user, and the user will probably click this advertisement. Next way is identification, which is connected to Clearview AI service. When the AI system has data, knows a lot about how to distinguish people, and is able to distinguish people and identify people based on the data it has. So identification of person allows law enforcement bodies to identify people as well. It is used in customs service work, and I believe that all participants of this event know about new initiatives of European Union. Actually, European Union is pioneering the use of AI in customs control, and the projects which they well tested for 5 or even more years. The e-border control project was based on the biometric identification and rather strict control connected with gathering personal data of people. And one of the projects allowed to read social media of a person and track person's activity in social networks based on their location, which caused uproar because it was inappropriate in terms of human rights. So these are some of the most relevant ways of personal data processing by AI, and I emphasize that AI system training and marketing goals are the ways of processing which are the most, well, problematic and attract most attention in the terms of this topic. So let's consider several cases which I found in course of my research. So I will present the first case, which is the most important and well known. It's the case of Garante Italia against OpenAI. So it deals with the fact, the situation when Italian supervisory authority found out about the data leak from ChatGPT and they started investigation on OpenAI. It was discovered that OpenAI didn't report about this data leak to Garante Italia, which they should have done according to GDPR provisions. And this behavior was incompatible with high standards of personal data protection. So in course of their research, of their investigation, Garante Italia studied very closely the work of ChatGPT, and they wanted to find the balance between technological progress, which was, well, promoted by OpenAI, and on the other hand, privacy protection. So I found the statement by OpenAI representative, I guess it was Mr. Altman. They said that ChatGPT and OpenAI should not be limited because their work is technological progress and future of humanity. So Italian Garante answered that they support technological progress, but they want this progress to be aligned with legal framework, human rights protection, privacy protection for every human being. On this slide, you can also see actually six main points of investigation, which later were laid in the basis of Garante resolution in the OpenAI case, the decision. So during the course of the investigation, this web service, ChatGPT, was blocked on the territory of Italy, which is unprecedented. It was the first case when supervisory authority blocked users on the territory of Italy to use ChatGPT. But later, it was unblocked and Garante was satisfied with their work and explanations provided, and it seemed that soon the case will be closed and this issue would be forgotten. But in the early 2024, OpenAI issued their decision, which shocked OpenAI representatives because it included the fine to be paid by the company. It's a fine of 15 million euro. It's quite a large sum. It was based on the provisions of GDPR and the system of sanctions, which can be applied according to Italian legislation and GDPR provisions. Besides, Garante obliged OpenAI to organize educational campaign on responsible AI system use on their work on using data safely in such systems, which data cannot be used at all or shouldn't be used. So OpenAI protested that decision. They thought that this decision is too strict and it doesn't reflect the level of danger connected with this violation. But as far as I know, this decision was not appealed as of now. Well, I may have named the decision wrong. So the decision was made in the end of 2024. So it's a recent case, so maybe it will be appealed still in the future. So this case of OpenAI and Italian Garante is the biggest scandal and the biggest case connected with data processing by AI systems. I'm sorry, Andrei, I must remind about our rules of procedure, about our time limits, so maybe you will go to conclusion. So how much time do I have? So the schedule says that you have time to 11:40, but you still have a couple of minutes. So I'm awfully sorry. So another case is the supervisory authority of France and the Clearview company. In this case, like the following one, there was an issue, a question whether the posting data online, does it make it freely available for processing? So if the information is already online, can AI process it in any way it needs for its goals? So this question in this case and in the following case was solved in the following way. If the information is online, it doesn't mean that it can be used freely without any legal basis. Unfortunately, we don't have time for DeepSeek. I will only say that more than 10 supervisory authorities from Europe reacted to work of DeepSeek, starting with Luxembourg recommendations and possible start of investigation by other authorities, because DeepSeek don't have representatives on the territory of EU, so they violate GDPR. So concluding my speech and thanking for your attention, I would also like to name the main violations which I found in the course of analysis of the information. First of all, we speak about material violations according to GDPR provisions which are connected with processing principles, like principle of informing, transparency, defending rights of subjects, absence of proper grounds. So supervisory authorities recommend to use legal interests as proper grounds, and to emphasize that this legal interest don't shift the balance of companies' interests and personal data protection interests. Besides, the special regime for spatial data is not created in all cases, like the children's data protection. So there are also procedural violations, like no representative in the EU, unpreparedness for data protection impact assessment, or this document is not according to all the requirements. And the last violation is refusal to cooperate with supervisory authorities. I've already mentioned that not all the companies who develop AI systems or use AI systems are ready to cooperate. So thank you very much. If I may ask Ms. Natalia to provide me a couple of minutes for answering the questions, if we have questions. Sure. Well, I intervened for the third time exactly in order to save time for discussion, because your presentation is very, very interesting. It really touches the most urgent aspects of data protection in the framework of AI. So I expect that we will have questions. So we have also a commentary in chat, but let's start with questions. So dear participants, do you have questions to Mr. Andriy? Mr. Vlad?
У мене є таке питання.
So I have a
Скажіть,
question.
чи можна вважати
Could you tell us
згоду дійсною, от, наприклад, коли
if
користувач
this
саме не розуміє, що саме буде штучний інтелект
consent
виробляти і саме які будуть
is
дані?
valid if the user doesn't understand what exactly AI will process, which data? Of course, from the legal point of view, such consent is not valid because the subject was not informed properly on the data which will be processed, but the practice shows that sometimes the subject is in such conditions that he or she just must consent to access the service they are interested in. Maybe we have some other questions. So no questions so far. So I will read the comment from the chat from Mr. Anatoly. So great, the consent of the subject is the key point of research and the practical use of AI. Once again, this consent as expression of will is important. Mr. Anatoly, could you please comment? Because I'm a little bit lost. So should we interpret that literally? So thank you for the possibility to ask my question. So I mean, well, I took a quote from this great speech which I heard. So I believe that the consent of subject is key in relations with so-called AI. So there is no sarcasm here, and I wanted to discuss in future the issue of whether AI or its part is subject of relation which we are discussing. And the next question is main. So we treat and interpret and look at the will. Will of who? A person as a participant of these relations, or on the other side, do we have a will on the other side too? Because I have impression that AI is, well, always wrong, but it actually doesn't make any decisions.
Дякую. Дуже цікавий погляд насправді на це питання. Давайте розбиратися, пане
Thank
Андрію.
you so much. It's a very interesting view on this matter. Let's dig into details. Dear Anatoly, thank you so much for all your remarks and questions. I just want to say the following, that when I was reflecting what topic to present for my audience, I just wanted to include the following question at the beginning of presentation, whether indeed the AI is the one to blame. And it actually resonates to what you have said regarding the consent issue. So yeah, while you were providing your reflections, I was thinking about the following. So this concept of giving consent, it's not just about formal putting a tick that yes, we agree or something like this. Maybe it's related to old days of the software development when we just like ticked a box to join some kind of agreement, and in such a way we signed it and were entitled to use it. So it's related to the software field. But of course, and it's also underlined in the previous question, discussion. Such consent is not a fully fledged concept in legal terms, and it requires some kind of improvements and implementation mechanisms in future. Regarding your question to receive consent from the side of the AI, so maybe it's been very beneficial to all the businesses when they have some drawbacks, some problems when, for example, AI was introduced without appropriate testing, piloting, without risk assessment, and going through the regulating sandbox. It's easy to blame an AI and to look some insecurities there, but not to work on correction of such drawbacks. Of course, users shall also bear their own responsibility because they shall understand what the AI is and realize that it's not just entertainment, it's a service which has both benefits and some backlogs, which also gives some advantages but creates some risks along with that. So thank you so much. Indeed, so interesting question. And yeah, Anatoly says that, so is it any kind of a personal blame for the AI? But yeah, thank you so much for all those questions. But because we are limited in time, maybe we shall continue this conversation in the written form, in the chat. So the question is who to blame, AI or a human being? And as we are limited in time and our time resources are the most valuable and we are guided by it. So thank you so much for your presentation. It's wonderful. It's related to the most urgent topics. And just recently, there was a draft law registered on decodification of the first and second book of the Civil Code of Ukraine. And one of the journalists actually reacted so much and so extensively to the issue of our right, so-called right to be forgotten, whether it's reflected or not in the two versions of the draft law. And it led to significant public discussions. And it's also related to the right to be forgotten in the context of the development of the AI. And the European Union countries, have already started this process, and they have already went through the first stage. They have already been under critics of the journalistic society. But we are still only at the very beginning of this process. The data protection legislation is quite weak in Ukraine, and all attempts to improve it somehow failed for now. And it now already is accompanied with discussions on AI, which is being developed so actively. And now let's move to the next topic. The next topic, which is actually dedicated to the secrecy or the confidentiality of correspondence, telephone conversations, and other communications in criminal proceedings in the digital age. And the presenter is Evgeny Isayenko, who is a famous lawyer, attorney at law, counsel at Green Law Firm, an expert in legal defense in complex criminal cases that require strong analytical skills, strategical thinking, and a high level of professional expertise. His experience covers all stages of the criminal process, from representing clients before law enforcement agencies at the early stages of investigation to defending against charges in courts of all instances. So, dear Evgeny, over to you, and thank you so much for being here. Sorry for being late, and over to you. Thank you. Okay, I hope you can hear me well.
Так, все гаразд, все гаразд.
Yes, yeah, all is good. Thank you so much for presenting me, yes, and covering indeed all my topics. And indeed, I'm an internet law practitioner and counsel, and thinking about which topic to present to you today, I was reflecting on the most urgent challenges, which are which become a pain stack to society, which we have no decisions and no solutions as of now. Andri's presentation was so interesting, and it gave me something new, and it inspired me to ask the audience a question at the end of my presentation. So I don't have a presentation today. I'm sorry for those who are going to listen to me today, but I will try to be as much concise as in my speech and to make it as much accessible as possible. Because, yeah, indeed, so we have so different questions raised in our legislative field, but because of the development of different technologies, some issues are yet not regulated as it should be regulated, and very often we have different criminal proceedings when access to information is provided without appropriate court regulation mechanisms to be applied. Those who are not very much related to the court proceedings, they shall realize that the court oversight is envisaged by the civil procedural and criminal procedural code in Ukraine, which actually envisages protection of rights and freedoms of human rights in Ukraine. And usually it's related to the issue of limitation of such human rights. And of course, when some amendments are made to legislation, not always you can prognose how technologies will develop in the future and how actually it will impact on human rights. So when I studied at the university and I worked on different articles or publications, and I think that our students also do it these days very often, we said that, the world is changing, evolving, technologies are being developed. And, 10 years ago, I graduated from the university. But anyway, even 10 years afterwards, I'm ready to repeat the same sentence, saying that the world is evolving. So the topic which I have opted for today, that's the confidentiality of correspondence, telephone conversations, and other communications in criminal proceedings in the digital age. We shall refer, first of all, to the legislation base, which actually regulates not only our obligations, first of all, reflected and traced by courts, but also that's about our rights. The Constitution of Ukraine guarantees the confidentiality of correspondence, and that confidentiality could be exempted or derogated only by the law. And the law which envisages it, that's the Civil Procedural Code of Ukraine. And Article 8 also says it's right to private and family life, which includes phone calls, correspondence, and right to private life. It's also covered by the Article 8 of the Constitution. When the Constitution was adopted back in 1996, such term was introduced into the Constitution in order to protect those rights which seemed to be obvious at that period of time. But when we're speaking about the correspondence as a term envisaged in the Constitution, that's about some kind of mail, letters, mail deliveries, packages, and so on. So something made by a person with their own hands physically. So something physical. No one could have imagined that everything, all our life will be in this digital device, in the smartphone. There will be everything, geolocation, or phone calls, emails, banks, bank accounts, e-wallets, and so on. So a smartphone or laptop, computer actually stores all information about us. And speaking about limitation of this or that right, smartphone or mobile phone, it's covered in very superficial terms by courts and court proceedings and their decisions. So, without understanding, without covering the issues that actually the smartphone and its content shall protect from all perspectives, including in the context of the right to private life. And it's clear why it happened, because maybe in 1996, phone was not a smartphone, something, just a device to make phone calls, and that's all. And we shall also realize that this right to communication is also protected by different means, but this right to personal communication could be realized using different phone calls. And within my profession, I focus on how it happens in criminal proceedings. And it doesn't matter what side you are, whether you are at the defense side or victim side, whether you're a suspect, a victim, court judge, or a secretary, anyone or anyone else, all your rights shall be fulfilled according to our highest law of Ukraine, namely Constitution. So the Criminal Procedural Code of Ukraine de facto is aligned with the constitutional requirements because it envisages some preconditions and provisions, and it also says that certain rights of a person shall not be limited without appropriate judicial oversight. It's also about immunity of housing, but sometimes it could be limited. And it's also envisaged by Criminal Procedural Code. And we have also a search as a separate investigative measure, and a search in house or location and dwelling can be done only based on the judicial decision issued by a judge. The same related to right of ownership, which can be limited only based on the relevant judicial decision, and if it's done for the sake of the interest of the criminal proceeding, public or the state, there shall be a relevant decision issued on the arrest and freezing of the dwelling. But at the same time, speaking about the confidentiality of correspondence, telephone conversations, and other communications, there are no specific actions to disclose this information is not envisaged in the Criminal Procedural Code, and that's to my opinion. And I think it poses quite a huge challenge, because in such a way, there are so different rights, human rights of a human being, which could be fulfilled using a smartphone. And in some way, in such a way, de facto, certain rights could be abruptly violated. For example, the confidentiality is guaranteed by the Constitution and Criminal Procedural Code, but at the same time, they say that actually it could be limited, but those provisions are focused on regulation of some covert and non-covert investigative measures, and there are some cases, for example, audio and video control and oversight of a person, confidentiality of correspondence, telephone conversations, and checking and wiretapping different phone networks and social networks. But everything, all of this is related to the confidentiality of correspondence, but it's related to limitations of the real-time conversations. When people communicate or interact between each other, they can expect that their conversation is private, and only in such a way, indeed, some judicial oversight is applied in the format of issuing an order to allow some kind of covert or non-covert, or covert or overt investigative measures. But all other types of correspondence, paper correspondence or other things, and I'm not going to cite for you different provisions of Criminal Procedural Code, but briefly speaking, provisions of the CPC are focused only on the paper forms of communications, but they do not cover any kind of communication or correspondence correspondence which could be contained in our smartphone or other digital devices. There is quite sound case law, for example, judicial decisions of the Supreme Court or High Court, that in order to limit such right, it's enough to take a measure on the arrest of the device, specifically a smartphone. And based on the fact that a smartphone could contain some files, could have some footprints of criminal offense, and I think that a smartphone shall not be considered as a simple and ordinary evidence, and specific measures of judicial control shall be introduced in order to ensure and guarantee the confidentiality of correspondence and conversations and other communications. Because now, even if a smartphone is being arrested, and even if pretrial and investigation bodies need to receive information regarding whether a smartphone has some certain files, or to define whether some identifying pieces of information there. But anyway, as soon as an officer receives a smartphone, he or she receives the right to check everything which is there. It could be chats, messengers, Gmails, other things, and everything which is contained there. And I think that that's a violation of rights and human rights and freedoms, because there is no judicial control over fulfillment of this specific right. This is one side of the coin, and which is definitely requires some place for improvement. Yeah, I know that there are so many different studies on this matter, but the Supreme Court case law, how to establish and guarantee the right of person for the confidentiality of correspondence, doesn't exist as of now. So yes, we have also another side of the coin when we speak about how to protect this right in criminal proceedings.
So there is a widespread practice for today which is connected of some specificities of pretrial investigation or some search activity when law enforcement bodies, to avoid unacceptability of evidence in the future, they conduct measures when one person communicates with other person using the cell phone, or when they send text messages, including via internet. There is a question whether a law enforcement body is planning to bring a person to accountability. They seize phones from other counterpart of communication, or the device is provided voluntarily. So the secrecy of correspondence is disclosed, is opened, and this information can be used to prove that the person is guilty in the future. So the Supreme Court tried one of such cases and came to my mind, contradictory conclusion, which states that if at least one of the participants of communication voluntarily disclosed the content of communication, so there is no violations. So it's there is a contradiction to my mind here, but no changes are planned in near future because there are no vision of law enforcement bodies on how we can change that in such a way that to comply with Constitution and CPC So there is also a case of some cell phones, mobile phones, smartphones, which are able to record all conversations which we had. Also, there are third-party applications which help recording conversations, and criminal procedure code is as it is to make some rules of conduct for law enforcement bodies describing the ways in which they can collect evidence, and articles like Article 86 describe the unacceptability of evidence, and Article 87 itself, which stipulates that evidence is unacceptable if it was obtained in contradiction with law of Ukraine or international treaties. So in this context, the legal practice is built in such a way that these rules are made for law enforcement bodies, prosecution side, and they should gather evidence in appropriate way. But if a certain person recorded conversations without informing counterpart of communication, so we have a question here. What if it happened before the criminal proceeding started? Like a person recorded conversations for years, and the other person could have not known about that. So, if we look at the human rights stipulated by the Constitution and the Civil Code, it's a violation because your rights end when you start to violate rights of other parties. Civil Code also provides for a right for free communication, so these norms are regulated not only by criminal legislation but also by civil legislation when we speak about correspondence. There is also criminal liability for breach of secrecy of phone communication, correspondence, or communication via electronic means. So in this context, returning to the question which was stated just now, whether this evidence is acceptable when the violation of human rights was made by third-party person, not by the state. There is no answer to this question as of now, because the Constitutional Court of Ukraine tried similar cases, like data obtained from recording devices provided by some person without procedural documents. Well, it's a kind of an old story, and legislation and practice changed since that time. And as of today, and why did I choose this topic? Because sometimes to prove the guilt of a person, phone conversations, recordings made before the criminal offense are used to prove that the person is guilty. And to that question, there is no answer from Supreme Court as well. And here we can mention the previous speaker who describes in detail all the specificities of data processing by AI. And I have a question here, rhetorical question. Is it possible that in future, with development of AI, when people will turn to it for help, for advice, what kind of advice we don't know yet? So, is it possible that law enforcement bodies getting access to device or computer will be able to see the content of communication with AI and will use it as evidence in court because it's a correspondence, maybe not with person, but they can see in the content of that communication, they can see evidence to prove someone's guilt in a criminal offense. And finishing my speech, I would like to note that the question is not only about court practice or the prosecution side. We don't have answers. How should we act to protect rights and freedoms of a person when we need to get access to their correspondence? How do we apply this court oversight and control? As of today, we know only about two forms of limitations of property rights of a person. One way is temporary access to property and documents. It doesn't work when the phone is already seized. Investigators cannot make a motion in court because the device is already seized. And this issue is described and reflected in the practice of High Anti-Corruption Court, which has own view with some nuances on the rights of participants of criminal proceedings. Also, it is impossible to use covert investigative actions to get access to correspondence of a person because such kinds of covert investigations will presume that access to correspondence or communication of a person should be gained by a law enforcement bodies secretly, without person knowing about existence of criminal proceeding. And here we come back to the same question, same issue, that it cannot be done because if a device is seized from a person in criminal proceedings, such person realizes that there might be questions in future, so these covert investigative actions cannot be applied. And the issue of seizure of property limits the use of one's property to study this or that thing or property like a cell phone or a computer. But in practice, I haven't seen cases where court oversight was applied in such cases, but the court oversight must be applied not only in cases of people who are brought to criminal liability or informed on suspicion. It also may be applied to witnesses, to search of property. So overall, I would like to draw your attention to the necessity taking into account of quick world development and influence of technology. We need to move in such a way so that our legislation will catch up with the development of technologies, and it would be oriented and upholding human rights and freedoms. So I'm finishing here. If you have any questions, I'm ready. Thank you, Mr. Evgeny, for your extremely interesting speech, which was full of practice, of empiric experience and evidence. We, as representatives of academia, not always pay attention to such practical, tangible material. We often work more in theory, but from your speech, we see that you experienced it all in practice and you know weaknesses of our legislation. So thank you for your great presentation. I see a question in chat from Anatoly Tarasenko, but I must change a little bit our style of communication in this panel discussion. We should, miss this interactive Q&A block because we are behind the schedule, and I feel my personal guilt for taking time from our next speaker. So if you have questions, write them in the chat, and Mr. Evgeny, please, if you have time, could you please answer the questions in the chat if you could? Thank you, sure. So thank you very much. And we have a comment from Anatoly Tarasenko there as well. So I would encourage both sides, both posing questions and answering questions, to discuss it in the chat. In the meanwhile, we are moving to the next speech.
Introduce our next speaker, Maria Bergström. She is an associate professor of European law at Uppsala University, Sweden. She holds a Doctor of Laws from the European University Institute in Florence. Her research interests and publications include judicial protection of private parties and EU criminal law and procedure in the area of freedom, security, and justice. Maria Bergström will deliver her speech on the following topic: problems and possibilities in cross-border gathering of electronic evidence in the EU, the example of EncroChat and Swedish courts. So, dear Maria, are you here with us? Can you hear me well?
Dear all, can you hear me?
Yes, we hear you perfectly well.
Thank you for your kind invitation. I just had some technical issues and my computer restarted, so I'm a little bit stressed about that, but I'm very happy to be with you, and I have listened to your very interesting presentations today. Unfortunately, I couldn't be with you yesterday, so thank you very much. I will, as Natalia so kindly introduced me, talk about problems and possibilities in cross-border gathering of electronic evidence in the EU, and touch a little bit on the EncroChat cases, and a little bit, not very much, about Swedish courts and how that has been dealt with. And I think this will interact or continue the discussions that we had this morning in this panel. I agree with you that there are many challenges linked to the increased use of ICT. In a wider sense, there are particular challenges linked to the increasing reliance on electronic reports, e-evidence, and other digitization themes. It can indeed be difficult to identify who is responsible, where certain information is located, and which rules should apply at different stages of the various processes planned to deal with such issues. And although police and judicial authorities have been cooperating with telecom operators and providers for decades, there's an increasing use of online services and new information and communication technologies, that is ICT, as I mentioned, that are usually addressed by private companies as technology companies and service providers. So this indeed poses particular challenges for police and judicial authorities collecting e-evidence to fight crime committed using or involving such technology. The information that criminals share or store using new ICT, thus processed by private companies, is usually not accessible to public authorities without cooperation with these private actors, which certainly involves a delicate balancing act between security on the one hand and protection of fundamental rights, which is the focus of attention today. On top of that, such evidence gathering and information sharing often involves a cross-border dimension, which then has been dealt with in the EU that I would like to share with you, making this balancing act of different interests even more challenging. In order to combat serious and cross-border crime, the improvement of information sharing is key. So, in addition, we live then in a time where the fight against serious crime increasingly takes place in an international context and where cross-border access to evidence and suspects is often essential to successful prosecution. And this indeed holds even more true for the fight against crime in the EU, where close cooperation and free movement means that cross-border criminality is a common feature. For a long time in the EU, we were left to mutual legal assistance agreements, rather complicated and cumbersome. But with the evolution of what we call is the area of freedom, security, and justice, and the emergence of judicial cooperation in criminal matters between the EU member states, there has been developed tools for facilitating cross-border gathering of evidence, including the main legislative act, the so-called EIO directive. There are other new rules, for example, the e-evidence regulation, but they're much more limited and in scope and so on, although directly targeted at e-evidence. The more general AIO, European Investigation Order Directive, has not been drafted with special attention to e-evidence, which make it sometimes problematic, but it lays down common minimum rules that govern cross-border exchange of evidence in the member states. And then there are, of course, as usual in this field, some states that are not part of this, Denmark and Ireland in this respect. It is based on the principle of mutual recognition of judgment and judicial decisions concerning criminal matters, and this is after the Lisbon Treaty in 2009, a new legislative power from the EU. And mutual recognition has indeed become a pillar of judicial cooperation in criminal matters, and allows judgments of judicial decisions from other member states to have the same force and effect as national ones, even if there is no prior recognition or recognition process. So this has really eased collaboration, cross-border collaboration within the EU. The instrument relies, as many other instruments based on mutual recognition, on the assumption that member states trust the legal systems of the other member states. It builds upon the assumption that there is mutual trust between the member states and that the application of the rules on criminal procedure and fundamental rights comply. Still, there's no a common ground. I mean, we have the European Convention on Human Rights, as we all are a part of, and within the EU itself, we also have the EU Charter of Fundamental Rights. But apart from those rules and partially harmonized rules in individual instruments, there's no common fundamental rights laws as more than these basic standards. So far, this means that each member state follows its own rules on criminal investigative measures for evidence gathering, which also means that there are different standards for admissibility of evidence, including electronic evidence in different member states then. So we have this directive, and this means that one member state can ask another to undertake investigative measures for prosecuting in the first member states, and that type of evidence is then added to the case file as any other domestically gathered evidence. So, and this touches upon then the interesting questions: what happens if the asking or issuing member states if evidence has been allegedly collected unlawfully, for example, contrary to the AIO directive, the law of the executing member state, or in breach in general of fundamental rights in the ECHR or the EU Charter. So, to give you some more information then, and to look at the example of Encrochat in Sweden, as I promised, one could assume as a starting point that when Sweden has issued an AIO and received evidence from the executing member state, the procedure is finished. On the one hand, since we have mutual trust and mutual recognition, and there's no questioning of the legality of the EIO or fundamental rights. One could also assume that the evidence obtained is accepted and added to the case file, as if it had been collected by Swedish authorities. But still, of course, in reality and also theoretically, there are concerns raised of what happens if the AIO has breached its legality or fundamental rights obligations, or whether there is need for further checks and balances, and so judicial scrutiny of the EIO process. And then to come to the example of Encrochat, because most notably in recent years, cross-border gathering of evidence through an AIO involves encrypted messaging services such as Encrochat. And Encrochat is, of course, only one of many that has been used by criminal elements throughout Europe and throughout the world. In this instance, Encrochat was a Dutch company that sold modified phones with an encryption communication, as many of you are aware of. They started a peer investigation in 2017, and then they had specific operative systems. I won't go into that, but the communications could take place by picture, text, or voice, and only with other than Encrochat owners. In the spring 2020, Dutch and French authorities under the lead of Europol, the European Police Authority, broke the Encrochat's encryption code, which means that they could follow and intercept the location, traffic, and communication data, including texts, voice messages, and images transmitted in ongoing chats of the Encrochat network users. And this was rather fascinating because when the encryption was broken, you could see exactly what they were writing to each other, sending to each other. And there are examples, even when murders have been ordered for and other types of criminal activities. It is still unclear what technical solution was used to get past encryption and to access the material, as that information was secret in France, so nobody outside those who have been working on it know exactly what happened. And almost all communication ceased on 13th of June 2020, as the company then found out that the system had been discovered, and it sent out warning messages to all its users. So it was in a rather brief window of time that the encrypted data was used and intercepted. And then when coming to the Swedish courts, I have, together with some colleagues in an EU Commission-funded project called the Mayor Project, with other universities in the European Union, looked at problems and possibilities with the AIO directive and procedures. And during this research, we also looked a little bit beyond what was the central theme of this project, and we looked into the difficulties that Swedish courts encountered when faced with this evidence, because Sweden was one of the countries in Europe that were allowed to get access for these messenger services through AIOs, then through AIOs issued under the system. And we looked at, since this was a limited period of time, there were only about 50 cases from Swedish courts of appeal that we analyzed in this project. And all AIOs involved were collected from France after Sweden had issued such an AIO. And on that basis, then we could identify what kind of issues and problems and human rights issues that came out in this and how it was used then in the courts. Many other countries have also used these information, these data set that the French authorities got access to. And it's very interesting to see how these data have been used and what different types of legal problems or issues were raised in different countries. And of course, Sweden is particular in this respect. And there may have been other type of issues in other member states, since it's still not harmonized rules on an EU level. I mean, the importance of this then, on one hand, we have the protection of fundamental rights and interest of the suspects and interest of the rule of law, and to have a just and fair trial, of course. And then on the other side, we have efficiency of the law enforcement proceedings and so on. And just to give you some numbers, that access to these EncroChat evidence in Sweden has, according to a study, led to the conviction of 320 suspects during the period, very short period of time, 2020 to 2022. And these were mostly persons with links to gang criminality in the 4 largest cities in Sweden. And these show how important access and use of intercepted EncroChat data has been in the fight against serious organized crimes. And it was mostly related to drug-related offenses, money laundering, weapons, and murder. And the Swedish law enforcement authorities even claim that they have been able to hinder murders that have been ordered during this period of time. There are, however, equally important concerns raised as to the use of EncroChat evidence. In particular, there are a number of challenges and risks to the defendant's fundamental rights, as I mentioned, as well as the foundations of the Swedish rules of evidence in criminal proceedings, but I won't go into that much. So this is why we thought this would make such an interesting case study. Since the AIO offers judicial authorities a simpler and faster alternative to the traditional instruments for requesting evidence, the cross-border element, where evidence is transformed from one legal system to another, brings particular challenges, of course, as I mentioned, but they may, individuals within these procedures may still be able to challenge evidence gathered in a number of member states on the basis of an AIO. Additional challenges may occur in the AIO if the AIO is tainted by illegalities or if the evidence has been collected unlawfully according to any of the involved member states. But there are also limits to this. The question has also arisen as to what effect an unlawful gathering of evidence could have on the use of the evidence in the trial. And there is no direct guidance in this respect in the EIA directive itself. So there are, of course, grounds for refusals, but not when it comes to these type of issues. In its Article 14, however, this article makes provisions on legal remedies, and it stipulates that those should be the same as in the member state. According to Professor Ligeti at Luxembourg University, she claims that the complexity of evidentiary standards creates a significant challenge, not only for defense practitioners, but also concerning improperly obtained evidence. And she gives the example where she mentions that whereas German law prohibits courts from basing a decision on such evidence, the Italian law requires that such evidence be excluded from the court's file. And when talking about Sweden, we don't have such formal rules in this respect, so such evidence could be allowed before the courts, but should be judged differently than in the evaluation of such evidence. So, although the system of evidence differs considerably between the EU member states, the European Court of Human Rights has taken the view that submitting to a court illegally obtained evidence that does not in general or in itself mean that the criminal trial is unfair. You need to look at the entire system and the entire trial to see if the defendant's rights have been taken seriously. Still, if we want to uphold a strong perspective of the rule of law and the clear human rights protection remains central to a sound development of EU criminal law that can be respected and enhanced. So it's still important to discuss these issues. And of course, the Court of Justice of the European Union has a key role in upholding the rule of law, as we've seen. And it's constantly refining and developing human rights in those collaborations with national courts, in close collaboration with national courts. I won't say so much about the other instrument where there are a similar developments, but you could have expected then that there would be an increasing number of cases concerning these EIOs and the respect of fundamental rights, that they should reach the Court of Justice. And there was indeed a very notable case, Gavanosov 2 case, two of them. The second came from the Specialized Criminal Court in Bulgaria, concerning absence of legal remedies in the issuing member states and decisions ordering searches, seizures, and hearing of a witness by video conference that has been extensively discussed and also led to some changes in several member states in their national laws. And this first case was followed by the so-called Encrochat case. There was ground chamber ruling with all the more judges of the Court of Justice than usual. That came from as a preliminary reference from the regional court in Berlin concerning the obtainment of evidence already in the possession of the competent authorities of the executing state and the encrypted telecommunication service of Encrochat exactly. So here many national authorities were a little bit worried what the Court of Justice would say, but it seems that since the evidential rules have not been harmonized yet and there are no specific rules on that in the AIO directive, in brief then, the member states could still use their evidential systems where there are other checks and balances and so on, and there were also other technicalities and interesting points that I don't have time to raise here. There have also been many other challenges where alleged criminals, suspects, have been challenging the use of Encrochat evidence. For example, before a UK court, which was, however, held inadmissible by the European Court of Human Rights in September last year. when the Court of Human Rights concluded that there had been a remedy available to the applicants by which they might have effectively challenged the data transferred. So they hadn't exhausted the domestic remedies, the court said. So we didn't get a substantial ruling in that case. All those cases, or the case before the Court of Justice, did not, in fact, change or affect how Swedish courts rely on this evidence. In half of the analyzed cases, about 25 from the appeals cases, where EncroChat evidence had been challenged, the defendant sought to have such evidence excluded, but the Swedish court allowed it, and when evaluating it, it did come to the conclusion that although the messages, even some were incomplete, they were so clear and of such high quality that despite various shortcomings, these messages met the requirement of reliability and exactitude to have a clear evidential value. In most cases, then, of course, together with other supportive evidence. And in the other half of the cases, there was neither a breach of the AIO, the defendant's rights, or the right to a fair trial in accordance with Article 6 of the Court of the European Convention of Human Rights. So in the end, all the cases allowed such evidence, and it further emphasizes that as long as we have not harmonized evidential standards and so on, and as long as those basic or minimum rules of protection of fundamental rights have not been breached, there is the system is still intact, and there are, as long as there is also a possibility of having a review before a court. Yes, I think I will stop there with those brief conclusions from my examples.
Thank you so
Thank
much,
you.
dear Maria. It was so interesting to listen to your speech, and I think your speech corresponds to the speech of our previous speaker, who tackled upon issues concerning, evidence gathering in Ukraine in digital era. And concerning taking the correspondence from this, wireless environment, and the problems of these actions in criminal procedures in Ukraine. So thank you so much. We have a couple of minutes, I think, for short questions, I think, before we make conclusions of this panel discussion. So, дорогі слухачі, чи є в когось питання до нашої спікерки, шановної пані Марії?
So, dear participants, are there any questions to our honorable speaker, Maria?
Поки що немає питань. So,
As far as I
see
understand,
that
there are no
listeners,
questions.
would like to raise questions. Maybe they still think about, formulation of these questions. I have a short question to you. So you mentioned that the rules on evidence gathering are not entirely harmonized across the EU, right? Can you range the legislations of member states according to the principle of the most up-to-date legislation in this regard and the less up-to-date legislation in this regard. So when we are talking about, for example, Ukraine, as we have already made sure within the previous speech, our legislation, unfortunately, is not very up to date. So we need to improve it, to make it more, future forward-looking, future-oriented. But is it the same problem for many European countries or not? Or most of the European countries have made, tremendous efforts to make their legislations better and better and more up to date? So this is my question.
Thank you. Thank you, Natalia. This is a very good question. I think it depends what perspective you take, because one of the basic rules of the European Union is that the European Union should only make new laws where it has competence and not interfere with the member states' rules when it's not needed, with the subsidiarity principle and the proportionality principle. And that was also why the lawmaker used many measures of judicial cooperation on the basis of mutual recognition, because there was not at the time a political commitment to adopt completely harmonized rules. On certain measures, yes, for example, access to a lawyer and access to information and so on, there has been consensus on those, or enough votes in the council to adopt such measures. But still, member states' legal systems, they work in different ways, and evidential value and access to evidence to the courts is one great example, because there are many variations throughout the member states. And in some member states, they're very formalistic, and they would not allow evidence that has not been produced in a certain way, or hasn't, if minor issues in the proceedings have been missed, even though it really does not affect so much the defendant's rights in a way, the whole evidence could be excluded or not used, which could be seen as maybe too formalistic from another system's perspective, such as the Swedish, for example, where the most important is to have a materially sound or just outcome of the case. That doesn't mean that if, for example, we don't have many examples of police collecting illegally evidence and so on. There are other rules in the constitutions to look into that and punish and make sure we don't have such a system, for example. But it could be also that in member states where there are very strict rules, the court cases go on for a very long time. Unnecessary long time, both for the defendant and the victims of a crime. So, for example, in Sweden, we used to have a much more formalistic system before, but we left that in the 1940s and onwards to make it more flexible and allow for those materially sound judgments. Then, of course, we should of course, as any other member state, follow the rules of the European Convention on Human Rights and other constitutional rules. But the idea is not to make all the member states in the European Union completely the same, but to allow them to keep some specialities, some themes and rules that have been there for a long time and work well within their system. And that's why we have mutual recognition then, that we should mutually recognize that the other member state system has applied all the relevant rules and so on. And it could also be that some member states are too eager to implement European laws that they don't need to. There are examples of that also. But all member states at some issues don't follow what they should do or don't do what they should, and then they're being punished by the Commission, sometimes quite severely by enormous penalty sums, etc. But it's a rather special system of give and take and collaboration together. And we all hope, of course, that Ukraine should join the European Union as soon as possible. And I'm sure you would be able to live up to the requirements the European Union puts on new member states. It's an ongoing procedure also in the current member states to live up to the demands of new challenges.
Okay, thank you so much for your optimistic forecasts.
Yes.
Yeah, sure. I realize that 27 member states cannot have equally, well-developed legislation, and the approaches differ from the jurisdiction to jurisdiction. And yeah, I think we should look at the best examples like Sweden and other legislations to make our euro integrational processes faster. And the criminal proceeding is the branch which is really very, very important for us to to make these euro integrational processes faster for Ukraine. Thank you so much, dear Maria. Щиро дякую. Щиро дякую нашим сьогоднішнім спікерам та
all today's speakers and participants for this fruitful discussion, which touched upon digital age. We, well, departed from our timing rules in the middle of the meeting, but we caught up and we are finishing the event according to schedule as planned. I would like to remind you that all of you received 2 action plans dealing with ways of improving our legal system and our business practices in the age of digital technology. If you have wish to comment or complement these plans with your thoughts, so please feel free to enjoy our company. Don't be shy and send us your comments to the same email from which you received today's invitation and link, and we will include your views, comments into the action plan. It will be published later on the website of our project, which I demonstrated in the beginning of the event, and it also will be published at university site. All co-authors will be mentioned. So thank you for attention and see you next year. Thank you, Natalia, for great moderation with slight humor, which allowed us not to be bored, and the event was lively. Thank all participants for great discussion, for information, for future thoughts. Thank you, Mr. Petro, for your moderation and help as well in the context of these emergencies in the lives of some of our speakers and co-moderators. Nothing terrible actually, but it's life circumstances which changed our plans a little bit. But still, we had a great meeting, so thanks you again. Thank you all and see you next year. Goodbye.